Let's take a look at your circumstance. You're Matthew Kyle Killian.
Yes.
File number here is 25955ST. You got a ticket at 4:36 p.m. at Dickinson Road and 131, driving suspended, no proof of insurance, and defective exhaust. That defective exhaust is a fix-it ticket, and if it gets fixed, they can dismiss it. Let's see why you're suspended. I looked at all these last night, but I can't remember that far back. Your license is canceled. April 16th of 25 in Indiana. Violation of out-of-state alcohol. You had an open intox here in Centerville in 24. No proof of insurance. Another drive-in suspended in 16. So you got Indiana problems. Do you know what the deal is in Indiana?
Yeah, I gotta go. I got court Monday down there, so I'm gonna see if I can get a Toxilock to get to restore my license.
What county is it in?
LaGrange.
All right, it's an OUIL charge? A drunk driving charge?
Yeah, I was on a 200cc scooter.
Oh, on a scooter.
Yeah, at my house.
And so you have a hearing Monday?
Yeah, the 23rd.
To try to get a interlock device. For a scooter or for a car?
Well, for a car. I mean, for my license back, but the offense was when I was on a scooter.
All right.
Kid's scooter.
Now, you haven't had a license in a while. Did you have a license in Indiana?
Yeah.
Well, you live in White Pigeon.
Yes, I just moved up here like a month and a half ago.
All right. All right, same thing. We'll have you come back on July 10th. We're sure gonna be busy that day. And bring your proof of Indiana stuff with you.
Well, is that like the Intoxilock thing or the?
Well, if Indiana gives you an Intoxilock, the prosecutor can decide what to do with this. But you got no proof of insurance and defective equipment. Did you fix the muffler?
I just don't drive right now because I don't have a license. So my girlfriend, we work together, so she just drives. She got a license and.
All right. We'll take a look at this. We're going to be busy on Thursday, July 10. Bring proof of Indiana license. And insurance. Now, this is just a pretrial. If it's not resolved, you can still have a trial or an attorney appointed if you wish, but we'll see what you can accomplish next week in LaGrange County. So I got the Hebron Road address in White Pigeon. Is that
Yes.
to go?
Thank you.
That circumstance where the lady wasn't printed at the jail is the quintessential case of why people should get printed when they get arrested. But I don't run the jail. I've also got a couple people that I could see from the jail while I've got Mr. Stickler. So in the meantime, let's call the people that didn't show up. Kevin Michael Engelmeyer has 2 counts of domestic assault. He has other charges pending. He's not in custody, at least he wasn't yesterday. He has another assault bound over to circuit court. He has a violation of bond conditions. And this one is supposed to have an attorney pretrial tomorrow, but I moved it to today. Mr. Truckee is his lawyer. Where's the other file? I thought I had the other case. I don't. Anyway, he is set for a pretrial tomorrow.
You rescheduled that number to 2 o'clock.
Oh, yeah, it's set for 2 o'clock today?
Yes.
Oh, okay.
Because he has health teams.
All right. Then he's still on here for this morning, so I didn't catch that. All right. Sebastian Gomez is charged with no insurance. Failed to appear. And then no cycle endorsement. We're going to do a ordered show cause. Now, we were successful with both show causes this morning. People showed up. John Elmer Fox Sr. has failed to appear, which is quite common. Mr. George was here. He has $753 of other unpaid stuff, and he appears on the right date and time about half of the time. This ain't the crime of the century. It's a disturbing the peace. I'm not going to do an order to show cause. I don't even know where he is. To a bench warrant. Bond $500 cash or surety. We'll try a 48-hour hold. I've known Mr. Fox for about 45 years. When I was here as an intern in the summer of 1980. Anyway, John Senior, you need to get in here and deal with this orderly case. We schedule links also for 6:25. All right, I'll continue to. Maybe a reason why he's here. Hi.
Josh has sent the prosecutor's office with the draft of the cases.
Oh, interesting. I'd still like to get to the bottom of it. Let me do this one more. Terry Wayne Frost. File 251015 failed to appear on a no ops. Again, we'll do an order to show cause, which is a time suck. Craig Frost was with Grant Funk and Bob Seeger. I don't know if he's related. Fail to appear for arraignment, try order to show cause first. These paper clips are connected together like a Chinese puzzle from Cracker Barrel. All right, Mr. Gomez didn't show up, Mr. Fox didn't show up, and Ross didn't show up. So they're dismissing Slavings.
Correct.
All right, Mr. Slavings, would you come forward? All right, has insurance and proper plate. Usually they'd reduce it to no proof of insurance, but they're gonna dismiss. And I want you to go out and check on that speeding ticket and you're good to go. All right.
Okay.
All right, Ms. Harmon. We got a couple of bench warrants. I'd be happy if we could just do them now, so. What'd I do with Ms. Harmon? Ms. Harmon, the prosecutor is going to dismiss your charge, which solves some of your problems. But if someone is out there with your social security number, your date of birth, similar appearance, I can't swear that it wasn't you in the picture that I saw. But if I were you, I would go here to the jail and inquire. I'd like to have them compare your booking photo to the person that was there. Because a couple things, whoever this is still at large, but I'm not sure why Thomas Caldwell would just say it was you. All right, please raise your right hand. You swear or affirm anything you're about to tell me will be true to the best of your knowledge and belief?
Absolutely.
All right, so your testimony is that the person that allegedly did the malicious destruction of property on April 13th, 2025 is not you,
Yes, sir.
and that you don't know Thomas Caldwell,
No, sir.
and you weren't living with him in a truck.
No, sir.
And You never got booked into the jail.
No, sir.
What?
No, sir.
All right. I don't know what to make of this. You've lived at that Hideaway Lane address for a long time.
15 years.
All right. My recommendation would you go out to the jail, because at some point, there's a record at the jail that you got arrested. There's a picture, which I frankly can't tell whether it's you or not. If I had a bigger picture, I could see it. In fact, I'll let you see it. And that picture ain't very good. Shows you had long hair. Did you recently get a haircut?
No, sir.
No.
Actually, it's recently been growing because I had it really short.
Anyway, this lady is apparently willing to be you. She didn't say, I'm not Christina Wheeler. And whoever this Caldwell is said it was you. So I'm confused. You have a birth certificate, says you're born in Sturgis. This lady says she was born in South Bend. Was your birthday 1975?
Yeah.
All right, case is dismissed. She was not fingerprinted here.
No, sir.
And the case is, I'd like to have one set of fingerprints on file, but if we print her, it's gonna go to that case.
Mhm.
So I'm not gonna order prints at this time. The case is dismissed.
Yes, sir.
But I would go out to the sheriff's department, see what you could confirm. Did Josh send any of those 20 pretrials in for a plea?
He's in his office. I'm not aware. I don't know.
I don't know who's doing them.
There is a hall full of people.
Is there?
There was, yeah.
Uh, I don't even know if they know they got them. There's 20 of them. Oh boy, that's gonna be, there's dozens of 20 people here. All right, well, let's take care of our in custody people as long as I've got you, and I'm not sure what the status of those pretrials is.
I didn't even get my regular email yet. Do we have any in custodies today?
We do. Well, I have 2 and Judge P has 2. I have Casey Willis and Autumn Long.
Or both? You're talking about both. They're both polys. Huh?
Yes. Hi, booking. This is Judge Middleton calling. Good. Could I see 2 customers, Autumn Long and Casey Willis? All right, thanks. Bye. That sounded like Brooke. Bingham. Is she working in the jail? Autumn Long is a retail fraud 2nd degree. Casey Willis is a domestic violence and possession of cocaine.
See that come back a little bit.
What?
Starting to see this cocaine thing.
We
come back.
have, we certainly have. I hadn't seen cocaine for a long
The
time.
economy must be booming.
And
People
we've
have
got a
goods.
guy who was pending trial in circuit court, had 53 grams of cocaine. Sweat had been working on him. And yeah, it wasn't a thing. I didn't see it for a long time.
53 grams, that's enough to share.
Yes, that's why he had a scale. Yes, people got better things to spend their money on than that. It's not quite as debilitating as some of the other things, but it's not the greatest. I really don't know what to make of that last lady. I'm gonna follow up on that further.
There are people around who claim they've seen her for a couple of years and that's what she looks like, so I have no idea.
Well, the other lady in the picture did look similar. She didn't have, her hair was longer, but it was such a poor picture that will. All right, let's see, Autumn Long. Yesterday, I was in this chair for like 3.5 hours. I got up and I was shaped like this. I have a theoretically a 10 o'clock trial. So if all those pretrials start coming in here. I don't know what to make of that Keogh kid either. Good morning, sir. What's your name?
Kenneth Munoz.
Did you just have a pretrial with the prosecutor?
Yes, sir.
All right, have a seat, sir.
Of course.
Oh, boy. Who'd you talk to, a man or a woman?
Oh, woman.
All right, thanks. Debbie must have come in late and started doing the pretrials. All right, have a seat, sir.
Of course.
Oh, boy. Well, the record's still on, the live stream's still on. Ms. Long. Failed to appear, did an order show cause, failed to appear for that. Hi. When did she start doing these, the pre-trials? Yeah, like just a few minutes ago? Okay, good, good. So she's been working at it.
Yes.
Okay. Good, that's good news. There's just a lot of them. All right, Mr. Munoz, why don't you come up to the podium there while we're waiting for the jail. This is file number 25. Got screwy numbers. 905-723 you're charged with a misdemeanor plate violation, failed to display a valid license, and speed. Prosecutor Davis has agreed to dismiss all of those charges for a plea to allowing another to violate the motor vehicle code. That one carries no points. Doesn't get abstracted to your license, won't affect your ability to keep or maintain your driver's license. Did you try to get a valid license?
I do have a valid
Oh,
license.
very good. So are you willing to plead to that charge of allowing another to violate the motor vehicle code?
Yes, Your Honor.
All right, you're gonna get a $225 fine. Other than that, did anybody promise you anything to get you to plead to this
No, Your Honor.
or threaten you?
No, Your Honor.
Do you understand if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes,
There
Your
won't
Honor.
be a trial. There was a trial, you'd have the right.
Washington State of Michigan is now back in session. The Honorable Judge Dave Jefferson presiding.
You may be seated. Court does call the case, People versus Linda Downer.
Conrad Siller on behalf of Pittsfield Town.
Morning, Your Honor. Dan Garrett on behalf of Linda Downer. She's stepping forward. Your Honor, for arraignment, oh, can you state your name, Linda?
Linda Downer. Thank you.
Your Honor, for arraignment purposes, we would waive reading and stand mute.
And in every way for a reading standing mute, court will enter a not guilty plea.
Your Honor, for pretrial, I inform Mr. Siller, my client is going to just plead guilty to the charge. I'm going to be moving for immediate sentencing, but of course, that's not a part of the plea and understand that as well.
All right. So she's just going to be pleading.
She is, Your Honor.
This is a 90-day.
Yes.
500. All right. May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Linda Downer.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of open intoxicants in a motor vehicle. Is that correct?
Yes, Your Honor.
That is a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, community service, and any substance abuse treatment the court deems necessary. You understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
All right. And to that charge, how do you plead?
Guilty.
All right. You understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You've signed any advice of rights form today?
Yes, Your Honor.
All right. Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will and because you believe that you are indeed guilty?
Yes, Your Honor.
All right. On the date of April 24th, 2025, Laura Road, Pittsfield Township, Washington County, State of Michigan, were you a driver of a motor vehicle?
Was I driving?
Yes.
No.
Well, you drove to Meyer, is that correct? Across the street?
Yeah, across the street. Yes.
Okay. All right. And were there open intoxicants in your motor vehicle?
Yes, Your Honor.
All right. What were they?
It was some wine that I'd been there for about a week or two.
So it was wine.
Yeah,
That was-
about that much.
How much? That much?
Lighthearted. Yeah.
Huh?
Low calorie, low alcohol.
Okay. All right. And it was yours.
From karaoke. Yes, Your Honor.
All right. Very good. I do have to advise you, ma'am, that well, it may not be applicable in this case, since I'm going to do an immediate sentencing, but if you do commit misconduct, like within the next few minutes, then this court, any evaluation or sentence agreement, the court would not be bound by. You would also not be permitted to withdraw your plea. Do that. You understand that?
I understand that. Yeah.
Counsel, have there been any threats, promises, threats, or other inducements which have led to this plea that have not been disclosed?
None from the prosecution.
No, Your Honor, thank you.
All right, very good. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. All right, anything you want to say, or she gets?
Oh, she doesn't look at, Your Honor.
Gallery, whatever.
Ms. Downer is 75 years young. As you've heard the facts of the case, I would respectfully request a fine.
Ma'am, anything you want to say?
Yes, thank you, Your Honor. I mean, no.
It's okay.
I don't.
Sentence of the court, fines and costs of $250. When can you get that paid, ma'am?
Today.
Thank you. Pay $250 today. I'll suspend 90 days in jail.
Right. Thank you very much, Your Honor.
Thank you. Your Honor. Okay, thank you.
Let's call the case, People versus Kamara Reed.
Ashley Lonnie for the people.
Morning again, Your Honor. Dan Guerin on behalf of Kamara Reed. She's stepping forward.
Go ahead.
Your Honor, Ms. Reed is here, I believe for a pretrial and a bond violation. In however order Your Honor would like to proceed, she will be admitting to the bond violation and then ultimately pleading guilty as charged. So however Your Honor would like to approach that.
Well, she's admitting to the violation.
She is, Your Honor.
Is that correct, ma'am? Yes.
Yes.
Yep. Thank you. All right. All right. And what are we doing on the case?
She's pleading as charged, Your Honor.
She's pleading.
Yes.
guilty as charged. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Kamara Reed.
All right. Ms. Reed, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Understand that?
Yes.
The court could also order any community service or rehabilitative service if the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that? Yes?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
She didn't, Your Honor, because she's in custody. I could have her do that now, or we could do that verbally, however you prefer.
Okay, you recall signing an advice of rights form, ma'am?
Yes.
Any questions regarding any of those rights?
No.
You'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that file.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
November 27, 2020, location of Carpenter near Chester Drive in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating?
Yes.
What did you have and how much?
I had a couple of seltzers.
Seltzers? All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
My lights were off.
All right. Were you ultimately arrested?
Yes.
Were you taken to the station?
Yes.
Was there a blood draw or a blood test?
Both.
Blood draw?
Yes.
All right. What were the results of that blood draw?
I would stipulate for the plea, it was a 0.09 blood test.
You have any reason to dispute those blood test results?
No.
No? All right. I do have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and your time of sentencing, that any evaluation or sentence agreement, the court would not be bound by. You understand that?
Yes.
I also would have to indicate that if you do commit misconduct during that period, you would also not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, I guess the first question is, have there been any promises, threats, or other inducements which have led to this plea which have not been stated on the record?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, I would say for the record, just so it's clear, the stop happened just after midnight. So the stop for no headlights I think is a valid stop. I think that they would stipulate that it was dark outside.
I don't.
Other than that, I'm satisfied.
We're satisfied as well, Your Honor.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be July 9th, 2025. At what time? 9 a.m. All right. Either as to bond, but as to the violation.
For the violation first, Your Honor, my client would waive her right to a hearing and be prepared to admit to drinking and ready to do that this morning.
All right. And that is correct, ma'am?
Yes.
You're waiving your right to a hearing?
Yes.
And you do admit, have you seen the violation report, ma'am?
No.
Okay, your counsel went through it with you, however?
Yes.
All right. And that there were on June 13th, 2025, that you were drinking?
Yes.
Very good. Court will accept that admission. How long have you been in?
Turned herself in yesterday morning. Is that what time is it?
8 a.m.
8 a.m. yesterday morning.
All right. How old are you, young man?
20,
How old are you?
21.
Where were you drinking?
Sorry. My dad passed away a couple of
Pardon?
years ago. My dad passed away a couple years ago, and I'm not handling it probably in the best way.
You were 19,
18.
18 when he passed away.
Yeah.
Let me ask you this, was that where your drinking started, or?
Yes.
And let me ask you this, I'm not gonna hold it against you, were you drinking a lot?
Yes.
Looking back on it, when you were drinking a lot, what do you think would happen for you? Probably don't know how to answer that question. I mean,
Yeah.
That's a tough question, isn't it? Suffice it to say, young lady, it would kind of make you forget and have the pain go away a little bit, right?
Yeah.
Okay. So, are you in school?
Yes. I'm supposed to go back next semester.
Did you finish up this semester?
No.
What happened?
I stopped attending my classes, so I had to withdraw.
Where were you in school?
It's my sophomore year,
At what school?
Eastern Michigan.
So when your dad passed away, had you already enrolled in school?
Yes.
And you made it through how many semesters after that?
2, and then I took a gap year, and then I went back.
Those 2 semesters that you took, how were your grades?
They were pretty good. I think I had a 3.2, 3.5.
Okay. You took the gap year, then you came back. How were your grades?
Okay, I think I had like a 2 point, I
Pardon?
think I had a 2.8 when I came back.
Where'd you graduate high school?
In high school.
Okay. Did you do well there? You got siblings?
I have a twin brother.
You have a twin brother.
Yeah.
Okay. What?
It's with mom in the corner of the courtroom.
Mom's on? Oh, okay. All right. So what do you think I should do with you? Well, before you answer that, let me ask you this. As you were going along struggling, trying to deal with your father's passing and things, did you let your mom know?
A little, but
Pardon?
not as serious as it had gotten. I don't think.
What about your brother?
I think he noticed.
You think he noticed?
Yeah.
Probably because he's your brother and also a twin, he probably did, probably felt it. Did you reach out to anybody?
I've been seeing a therapist weekly.
You were?
Yes.
Okay, so how long have you been doing that?
I was seeing one I've been seeing her for like 7 years, and then I've been seeing one who specializes in grief for the last 3 months, I think.
Okay, so something that you started heading in that direction, dealing with her. Okay. How's that working for you?
It's going okay. I think I've been thinking about seeing someone else.
Pardon?
I've been thinking about seeing someone else. I don't know if it's a good fit.
Okay, so your therapist might not be fitting with you, right? Okay. All right. Now I'll get back to you. What do you think I ought to do with you?
Sure, I guess whatever punishment fits.
Give you a chance to prove you can stay sober.
Yeah. A chance to prove I could stay sober, I think.
You think you can?
Yes.
That wasn't real confident the way you said that.
I want to, and I think that I can.
Young lady, why do you think I asked you all of those questions?
See why I did it, I guess.
Yeah, maybe. Here's the thing that you don't understand and are just beginning to kind of explore. Grief is a horrible thing in a lot of ways. It becomes real bad if you don't deal with it. It kind of just sits there, and then at some point, while you try to sort of bottle it up and push it down, it somehow or another just all of a sudden begins to explode. Right? And then at some point, because you're not dealing with it, you're kind of out of control. And then it becomes harder. At the beginning, you probably could have told somebody, but by that time, you don't tell anybody because it becomes hard to explain. Right? And it becomes real difficult to, no matter how close somebody is, even talk to anybody because they're not, you don't know if they're going to listen or they're going to take time to listen. And the reality of all of that is what you want is you just want that hurt and other things to disappear. Right? Were you close to your dad?
Yeah.
Something's gonna. I'm gonna guess, but I know I'm right because I'm always right. But I'm gonna guess that you were daddy. All right. Look, more than anything, and I'm going to tell you, I don't always talk about myself, but I'm going to tell you why I asked the question. Here I sit all these years later. I lost my dad when I was 16. So when I'm asking you those questions about grief, I get it. Okay. I'm going to let you know that if you find a way to kind of deal with it, you're going to make it through it. Okay. I didn't know your dad, but I can almost bet that he'd want you to make it through. He wouldn't want you trying to do this, trying to deal with all of this on your own. Okay. So in the interim, how am I gonna keep you sober? Young lady, there's just right now, and partially because of the age you are, partially because of what you've been dealing with, a lot of things in life are real confusing right now, right? You're not sure the next step that you're taking, what direction that's going to head or what you're going to do, right? Okay, here's a suggestion I'm going to make to you. I want you to take whatever steps you're taking slow. I'm watching your mother over there. She's goosenecking trying to look over Miss Pilara's head, but your brother has been right all up in it. Okay. What that tells me is you got a family out there that'll just love you, they'll support you. And if you hadn't told them, probably after today, they'll sit for whatever time and just listen to you. Okay. And as you let it pour out to them, and I'm going to tell you, it's going to come out wrong. It's going to come out crazy. You may think yourselves crazy as it's coming out, but just let it come out. Okay. Said she turned herself in yesterday.
Yesterday morning, yeah.
what I'm gonna do. I indicated defendant is admitted to violation. I don't think it does any good to keep you incarcerated at all. All right. So I'm gonna sentence you on that violation to 2 days in jail, credit 2 days use. I'm gonna let you go. I am gonna, however, order that you report over to the Department of Community Corrections. We're gonna put a scram tether on you. Okay? You got that?
Yes.
All right. You are going back to school in the fall. That might have sounded like a question. It wasn't. Okay? And that, you can take that as an order. You're gonna go back. You're gonna just sort of walk that journey through life and do that, okay? You hear me?
Yes.
And I'll sign that scram order and we'll get you over there. All right, young lady?
Thank you.
Thank you, Your Honor.
Well, you're welcome. And most importantly, sometimes what you just have to do, you just have to be kind to yourself. Okay,
Okay.
got it?
Yes. Thank
All right. Take care.
Thank you, Your Honor.
Thank you.
You.
I know, I didn't think that you did, because you would have asked me about it. Let's see. Your Honor, does Mr. Harvey have an attorney on the OWI case?
I don't think it's been authorized yet.
We sent it down on 6/9, so 10 days ago.
It ought to be somewhere.
Yeah, I was gonna say.
These to the ladies in the criminal department. We're about to address James Michael Harvey's domestic violence case. The prosecutor's office submitted a warrant request on a OUIL for the day he drove to court. And they said they submitted it on June 9th. So if somebody could find that, maybe we could address that this morning. And what I'm told is that they have a hard time hearing me. No, we'll see. Yeah, why don't you ask?
Just get them on.
Um,
So we still did the 6-month delayed sentencing. And then if everything's going well in 6 months, then I would just drop it down and keep them as bright. Yeah.
All right, this is file number 25366 SM, People versus James Harvey. Good morning, Mr. Harvey. You've been in jail about a week now, and you look good. No offense, but that week in jail, I think did you some good. This is the time and date set for a bench trial on a charge of domestic violence. It is alleged that on February 28th, that you assaulted Kylie Wilma, someone you had a dating relationship with, and Grayson Lewis. It was an assault and battery. We had several pretrials in this matter, and you agreed to have the matter set for a bench trial this morning. And I appreciate your faith in me. You were willing to have this matter tried in front of a judge alone rather than the jury. So we set the matter for trial this morning. Last week, there was an allegation of another bond violation, and I canceled your bond after a hearing, and the matter was set for this morning. I'm advised by Prosecutor Davis and your lawyer that an agreement has been reached, and you're going to enter a plea this morning pursuant to a plea agreement. Is that your understanding, Mr. Harvey?
Yes, Your Honor.
All right, Ms. Davis, could you fill me in here?
Sure. So, Your Honor, I don't believe he's been arraigned on the OWI yet.
He has
based on
not.
What I'm seeing, but Attorney Bush has agreed to represent him through the MIDC contract on that OWI, and we can make it part of a package deal today to resolve all of his open cases. So I believe there's a bond violation that was pending too, but we would dismiss any.
I think I did that.
Take
That's
care of
why
it
he's in
already?
jail right now.
Okay, so I don't believe there's any other cases besides the OWI and then this domestic violence and assault and battery. So the agreement would be that he would plead to a DV first, but we would agree to delay the sentencing for that for 6 months in order for him to seek substance abuse counseling, mental health counseling, which would include getting an evaluation, following the recommendations of that, taking medication as prescribed, and signing releases so that we can monitor that. If he is compliant with that, then at the time of sentencing, we will reduce the domestic violence to a disturbing the peace. With the OWI case, he would be agreeing to plead.
Slow
to-
down a little bit. Let me get this. All right.
For the OWI case, because he does have a prior, and I believe 2019, we would agree that he could be referred and put into sobriety court, and that it would be an OWI first that he would enter a plea to. And the thought is that no further jail time up front. We want to get him referred and started in sobriety court as soon as possible so that he can get going on that. And again, these would be kind of running at the same time, the sobriety court, probation for the OWI, and the 6-month delayed sentencing, as long as he is compliant with what they are asking him to do, then we would reduce that domestic violence to a disturbing the peace, and he would continue on in that sobriety court probation. And we did discuss that if he fails, bombs out, has assaultive or threatening behavior, or drinking alcohol, whatever, that would result in a bond violation, and he would be brought before the court as soon as possible. And the deal will be off the table as far as the DD.
All right. The complaining witness, Ms. Wilma's been here every step of the way. Are you on board with this?
Yes, I do agree with it.
Any luck with that?
No.
Would you like me to email you the OWI report?
Well, I can't take a plea till we have an actual file on it. But yeah, let's talk about this. Mr. Harvey, this is an interesting plea agreement. You're charged with domestic violence and assault and battery. You're gonna enter a plea to domestic violence, first offense. It's punishable by up to 93 days in jail and a fine of up to $500, and would prohibit you from using or possessing a firearm. The prosecutor has asked me to use a special deferral statute. We don't use it a lot, but it does allow the judge to defer sentence for up to a year. In this case, she's asking for a deferral for 6 months, which would take us into December. And if you comply with their directives, and they're a little bit unclear, but you're to get a substance abuse evaluation, you're to sign a release, participate in treatment, either mental health or substance abuse or both. You're also at some point going to enter a plea to an operating while intoxicated first offense, charged as a second offense. They're going to recommend that you be placed in the sobriety court program. Now, that's not a done deal, that we have to have an assessment and make sure you're eligible. Personally, I believe you could greatly benefit from sobriety court program. I'd be all over you and we'd be working together, try to get your life in a better place. But so far, we don't even have the complaint. Ms. Davis thinks it was sent on June 9th, but our file, we don't show that we've received it. But at some point, we're gonna receive it. Mr. Bush has agreed to represent you in that case. Drunk driving, a second offense, also known as operating while intoxicated, is punishable by up to a year in jail, fine of up to $1,000, 6 points on your driving record, and requires that your license be suspended. If you go into a certified sobriety court program, you could actually get your license through the program with an interlock device as a restricted license, would let you drive back and forth to work. In fact, that's your only avenue to get a restricted license, with a very narrow exceptions for 5 years. Every time I've seen you since you were a kid, you've always been polite, respectful, you're here on time, but you have a terrible alcohol problem. And if you could stop, you would. But it isn't that easy. It's like holding your breath. At some point, you got to breathe in. Sobriety court has a number of components. It has treatment in the form of a private therapist. It has a group setting where you're in a group treatment program that I pay for. You participate in AA or Celebrate Recovery or other report group or support group. We test your urine several times a week to make sure you're not using any drugs or alcohol. And you meet with me as part of your punishment every 2 weeks so I can poke around in what's going on with your life. It's a probation where people actually care about what happens. Not that they don't care in the other ones. We just spend a lot more time on these. So I can't arraign you on that charge yet because I don't have it yet. But let's talk about this domestic violence charge. My understanding is you're going to plead no contest to domestic violence or domestic assault.
He has somewhat hazy memory of exactly what happened.
All right. Having a hazy memory is one of the reasons for no contest. By pleading no contest, you don't admit what happened, but you also don't deny what happened, and you allow or accept that a conviction will enter. This happens when people are sometimes intoxicated. They don't completely remember. Sometimes they hit a tree in a drunk and they wake up in the hospital. They don't remember anything. There are other reasons for no contest, but lack of memory is one of the primary ones. So are you going to plead no contest to the charge of domestic assault from February 28th?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No, Your Honor.
Or promise you anything?
No, Your Honor.
To understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury, and there will be no trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush is representing you in this case, and he's always welcome to represent you in the next case, which kind of reflects on you, which means you're the kind of client that listens to their attorney and complies with court orders for the most part, rather than, so he's willing to accept you in the next case too. You could also hire an attorney if you wished. If you had a trial, you'd have the right to take the witness stand and testify in your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Understand?
Yes.
You've heard me say all that before, but, so let's talk about this. I did get a bond information booking sheet from Officer Etter, who's here today. They were dispatched to an allegation of assault at 430 Second Avenue in my old neighborhood. And they saw you jump over the fence, the house on East Michigan Avenue. This was 1936, so about 7:30 at night, which will be dark in February. Then they found you and put you in the car. Spoke with Kylie Wilma. She said she and James have been dating for 3 years. Kylie said she came over to the residence because she saw James' location, knew he'd been drinking. Kylie said James was sleeping on the couch and she tried to wake him up. Once she woke him up, he was very angry, or he swung at her and struck her in the back of the neck with his forearm. And her son got involved. Okay, Diana's looking for the warrant at your end too, and we're looking for it at our end, so maybe between the two of us, we can figure out where it is.
Thank you.
All right, so that's it, and I could see why you're drunk, you're asleep, you wake up and you end up hitting her in the neck. Then her son gets involved, and then that's not good either. All right, I'll use factual basis from bond report. Six months from now, we're in the holiday season. I set this for sentence for December 15th. That's somebody's birthday. At 10:30. Mr. Bush, I'm assuming your calendar's good for that.
I've been that far down the road. I'm okay.
At this point, yeah, we're not to the point where we have to schedule people 6 months out to get a clear date, but I'm pretty sure that we're
I'm not concerned at all.
good for that date. Let me see what your blood alcohol was that night.
Or those are 0.19.
Looking at the booking stuff. 0.198, so that's. What's your drink of choice?
Captain Morgan.
Well, that'll do it. And every time we've had you here, your blood alcohol's been very high. And so you've got quite a tolerance. Did you feel like you were going through withdrawal when you've been sitting in the jail for the last week?
No.
No, that's a positive thing. Because your bond is going to continue to say no drugs and alcohol. So 2 times so far you've been locked up. But you can't stop without doing something else. So I want you to start going to AA or Celebrate. I want you to get plugged into Pivotal or other treatment provider. And we're going to need to get a date for your arraignment on the drinking driving charge. I wish I could take care of it now, but I can't find it. Because I don't want you to get arrested on a walking down
We
the
could-
street or something.
We could certainly have it be a summons.
All right.
If the warrant hasn't been processed by district court yet, we can switch it to requesting a summons. Hopefully within the next few weeks. The idea is we want to.
Here's Diana. She's the person that always has all the answers.
Okay, so Your Honor,
Okay.
the sheriff's department has not gotten us an affidavit, but I don't think they realized that now he was in custody, so she's gonna take that to Shayna so that you can just
All
arrange
right.
him.
We will send you a summons and with notice to Mr. Bush on the new charge.
Looks like he's gonna be at that Haber Drive address.
We would ask that the no contact be lifted, discuss that at length with the victim. And we believe that with the bond conditions in place of no drinking, having him testing, no assault or threatening behavior, and hopefully getting into sobriety court, that it will be a safe situation.
Well, if he was in sobriety court, I'd be very comfortable because our staff will be on him, the DRC will be working with him, I'll be seeing him regularly. He'll be going to treatment. It's gonna take a little while to get from here to there. Miss Wilma, do you have any objection to lifting the no contact provision?
No, I don't. I'm not like concerned about.
I think our concern was where he's going to stay and making sure that he's in an environment that supports his sobriety and. her
Who lives at
home is-
Hubbard Drive?
Well, that's her
Okay,
place. So, and if he's not permitted to go there, then her concern is that.
I'll let him go there, but it might put her lease in jeopardy. He's not on the lease, but that's up to her, I guess. The other thing is, I'm gonna let you out of jail. Now, we have a bit of a wrinkle here. I put everybody on notice. John's aware of this. He works for a company and I know his boss and known him since he was in high school. My wife had him as a student. She's recently hired his company to power wash my house and forgot my roof. So you might be at my house.
All right.
So don't fall off my roof or break a window or something, but I know your boss is probably chomping at the bit for you to get out of jail. Yeah. So has he held your job for you?
I believe so.
All right, bond remains no alcohol. Test on demand. Enroll and treatment at Pivotal. Get an alcohol assessment. No assault or threatening behavior. And what we're trying to do,
Ms. Davis would also like him to sign a release.
oh yes, thanks.
And then if it's possible, he was on the Scram tether prior on his probation, which was very successful for him and keeping him from drinking. If that's something that we could institute for his bond until sobriety court gets started.
Well, if he's eligible for it, otherwise it's gonna be very expensive.
Or even just color call-in testing at DRC, some sort of testing. so
He's
that it's
gotta,
not
then
just-
he's gotta pay for it, and it's very expensive. When we get him into our, if he's eligible for, was he on pretrial services?
Have you had to deal with MIPS Bliss?
Yes.
He says yes to that.
All right, return I think it got dropped and then never got picked back up.
So, if I'm OWIL, they're getting it in system, so do you want to arrange on that today?
Might as
or-
well.
Okay. Might be a minute.
Sorry, I feel like every time I look at the computer, so.
It doesn't have to be this bad. You and Miss Wilma can have a much better relationship. You can have a better relationship with her son. You can feel better at work. You can feel better in general. You can lengthen your life by about 30 years if you can stop drinking to the great excess that you do now. Now, you're killing the pain with alcohol. And to make sure you kill it, you drink about 3 times more alcohol than you could have to legally drive a car. Like I said, the day you were here, you were a 1.7 and you were walking, talking. We weren't even quite clear, except one of the spies smelled alcohol on you and we followed up on it and holy smokes. So as I said, you seem like a nice kid. Your boss likes you. You just need to get sober or you're gonna have a rotten rest of your life. And you can't do it unless somebody like me is standing over you with a stick. You also have a carrot that you may be able to get your driver's license with an interlock so you can get to work and treatment and other stuff. So the bond was originally posted and I revoked it. Canceled it. So I'm gonna reinstate bond. What was it originally? $7,500, which you already forfeited with quick bail bonds. I'm not gonna make you post another one. Reinstate bond of $2,500 PR with conditions as above. Debbie, do you know if any more pre-trials were coming in?
I don't, Abby has been handling those all morning.
All right, we'll see how that goes. We had a bunch of them and I only got 2. All right, Mr. Harvey, the first couple days are gonna be the hardest. You're gonna, as soon as you get out of jail, you're gonna want to drink. Do you smoke?
Yes.
Well, the first thing you want to do is have a cigarette. Second thing you want to do is have a drink. I can't stop you from smoking cigarettes. But you had a good head, you had a 7 or 8 day start on not smoking cigarettes.
I said I was gonna switch to gum. and
That might be a start. Maybe try Nicorette. But you can't drink any alcohol because you can't have one.
Yeah.
You have 14. And you buy the Captain Morgan by the half gallon and it's killing you. You got somebody that actually cares about you. There's reason enough to try to get it together. All right, I'm still waiting for this paperwork. We didn't have it, but prosecutor staff got it down there and they're processing it. And so we'll start that. John, my thought is, I don't have enough to do on July 11th. I only have about 95 cases, but we'll arraign him, show a plea of not guilty, appoint you as his attorney, set a pretrial. It might even be wise to go to August 1st.
Is there any reason why you can't enter the plea today?
No.
Yeah, I think that was what,
Yeah, it was,
that would get him into the system.
It certainly would.
So I'm running a little bit there. I mean, I was there, so I remember it was an
Yeah.
accident. And that person knowledge he drove here, but I've not seen a police report, but I'm not uncomfortable if we can enter the plea today. That's what he wants to do.
All right, there is a wrinkle that potentially you could be a witness against him. But I think he can waive that.
I believe that he can waive any conflict. There's certainly other raised just eyewitnesses. So I don't think it's an issue.
All right, well, that would be great, Mr. Harvey. That shows you're ready to jump in and and I'd much rather sooner rather than later. You're salvageable. And it doesn't appear we got any more pre-trials coming, so we're not in a terrible time crunch.
We're getting a lot accomplished this morning.
Yes, that's worthwhile. And at some point, when we're done, they can pick you up at the jail. Shayna or Jenny or anybody, did any of those pre-trials get set for a plea this morning? There were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. About 17 or 18 of them. We're going to set them all on the same day. And once again, we had several more suspended drivers drive to court. We had a busy afternoon too. You're right, Deborah. It does show a violation of bond condition. I think you're right. I think I didn't find the bond violation. I canceled his bond and set it for a hearing on the bond violation for today. So you're also willing to dismiss the bond violation?
Yes, and I just want to make it clear to talk to Mr. Bush already, and I believe you confirmed it with this client. There is a warrant request for authorization on a malicious destruction of property for a broken window from that incident. And as part of this, with the plea to the OWI at the Sobriety Court, he would agree to pay the restitution, which is estimated at $250, and I would decline to authorize on that account and dismiss the bond violation. And I would note that his PBT on the 12th, when he got taken in for that, was a 0.208 at the jail. And he had driven his vehicle to and from Miss Wilma's apartment. So again, I would ask the court to consider having pretrial services.
I did order it.
And a scram.
I was on a phone call, I couldn't get off. I'm sorry. That took so long.
Thanks, Shane.
I'm sorry.
And they are still working on pre-trials.
Oh, boy. Yeah. We need to start those right away at 8:30, not at later. All right, Mr. Harvey, let's talk about this. In for a penny, in for a pound. Been saying that a lot lately. Won't use a penny anymore. I want you to say what, in for a nickel, in for a $5. Well, that's not in my queue. There it is. No, it's not in my queue. I gotta do a scavenger hunt. All right, this is file number 251157 SD, People versus James Jonathan Harvey. That's you, sir?
Yes, Your Honor.
The allegation is that you were operating while intoxicated as a first offense on May 15th of 2025. That is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. I believe you have a prior drinking driving charge, but it might be too old.
It's in 2019. I believe.
Yes, but they didn't charge it as a second offense, it's charged as a first offense. So part of this overall plea agreement we've just discussed is you're gonna enter a plea to that charge of operating while intoxicated. You're gonna be placed on a deferred sentence in the domestic violence charge. You're gonna be referred to sobriety court for evaluation and possible participation, and I'm all in favor of it. But there are some steps we have to go through. As I indicated, because you do have 2 OUILs within 7 years, they're gonna revoke your driver's license. Means it's gone for 5 years. If you do a sobriety court program, you'll be able to get it with an interlock. Do you understand the charge?
Yes, Your Honor.
Other than the plea agreement that the prosecutor is not going to charge you as a second offense, they are referring to sobriety court, and it's connected to the plea offer and the domestic violence charge. Did anyone promise you anything to get you to plead to this?
No, Your Honor.
To understand that if you do plead to this charge, you will be giving up your right to have a trial in this matter.
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney, and I'm going to appoint Mr. Bush to represent you in this case.
Now, could you put up the conflict issue while you're doing that?
Yes, do you have any objection to Mr. Bush representing you in light of the fact that he saw you there that day?
No, Your Honor.
Thank you.
You understand that if you had a trial, you'd have the right to testify in your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt.
Yes.
Understand? All right, this was May 15th. That was a Monday. No, it was a Thursday. There's no affidavit. Was this the day that he drove to court
Yes, Your Honor.
and they gave you a breath test later and it was a 0.198? Yes, and was it Captain Morgan then also?
Yes.
All right. Out of ROAs, I got about 3 left. That'll get us through the morning. Okay, Mr. Harvey, this is quite a comprehensive situation here. He's gonna need to get printed on this, so maybe we'll do that while he's here. Mr. Harvey, I'm sorry you had to get a drunk driving to get into sobriety court. We don't have a corollary of it other than that. It's expensive and time consuming to run it. And there are some guidelines about who's admitted and who isn't, but I think you're gonna fit our guidelines. All right, let's pick a sentencing date. Gonna need to set it out a little bit. Accomplish everything we need to accomplish. Not good. Well, I might have a really good day on August 4th. I have a dentist appointment in the morning and a doctor appointment in the afternoon, but I think in between there, we could set this for 11 o'clock on Monday, August 4th. Does that work for you, John?
For some reason, I'm not getting service in here to check the computer. What day of the week is that?
That's on Monday. Let me call your office. Good morning. This is Judge Middleton. I'm here with John and Debbie Davis. I want to see if his calendar is clear for Monday, August 4th at 11. All right, put him down for James Harvey sentence. All right, thank you.
Thank you, Judge.
All right, according to the person that knows what's going on, you're free for that day. We got a lot to do. I need to set a bond in the drinking driving case. Bond is $500 PR. We got a lot of different orders doing all this stuff. No drugs and no alcohol. Test on demand of any police or probation officer. No weapons, no assaultive behavior. Pretrial services. Doesn't have it on there. That's an older bond form.
Yeah.
Why don't you have him sign that right while he's right here? We'll get a print. We'll get contact with pretrial services. You gotta call them. And you're gonna need to get plugged into AA, James, because otherwise you're gonna relapse real soon. And we're gonna be back in it. All right, I'm hopeful here. I'm hopeful that you and Miss Wilma can get it back on track. I'm hopeful we can get from here to the sentencing date without you violating the conditions of your bond. And I'm hopeful that you can get into my sobriety court and I can get you through the domestic violence case. If you can't, the jail's always there, which you've learned. All right, they're gonna take you back. You're gonna get booked out. Got a $500 PR bond and then PR bond in the other case. So probably maybe by lunchtime, you can pick them up. Might be a little slower than that by the time they get all the paperwork there, but all right, Mr. Harvey, do you have any questions?
No.
All right, I'll be seeing you. I'll see you at your sentence, and if you go into sobriety court, I'll be seeing you all the time. All right, you're good to go.
Thank you for this opportunity.
Thank you, Judge. Thank you, Ms. Davis.
Yep, good luck.
Oh, these go, John, why don't you take these out to the counter? So they can get that started. No, this one. If there's pretrial supervision, it's not on there, but I guess I can continue to use the old ones if there's no pretrial supervision.
So you need more.
No, that's fine.
You need more copies of this, is what I'm asking. Yes, see what I'm saying?
No, I got enough of those.
Okay, great. Because you're early, so I had to print it out.
This is everything for the counter, Judge?
Yep. Okay. All right, thanks.
Yeah.
And I guess
There's
we were
more
working
coming.
on one more.
In fact, wait a minute, John. See also. 25, 1, 4, yes. All right, thanks.
I will deliver.
Okay, he's gonna deliver.
Yep.
I have no deliveries.
Okay, thanks, everybody.
You just have to be kind to yourself. Okay,
Okay.
got it?
Yes. Thank you.
All right. Take care.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Beavers. Who's approaching? Ms. Beavers, please state your name for the record.
Tasha All right.
Your Honor, we are requesting an adjournment. Ms. Beavers is enrolled in treatment at Home of New Vision. The resolution on this case basically depends on her completing or substantially completing a portion of treatment. So I just asked for a lengthy adjournment so she can kind of get in and start.
Was she at home now?
So I've never seen this. I was explaining this to Miss Beavers. She was released from the jail yesterday to Home of New Vision. They said she wasn't eligible for inpatient and told her she can do outpatient. So I know Your Honor ordered her to do inpatient, but they told her she can't, essentially. So I've never seen that, because typically if Your Honor orders inpatient, but they did do an assessment, and I did review that with Miss Beavers. It's pretty lengthy. It's like, 30 pages or something. And I guess that's what she assessed her for. So, but she is enrolled and she'll be going 2 to 3 times a week at Home of New Vision.
All right, any objection to the adjournment?
No, Your Honor. Ms. Pilara just handed me an email from Home of New Vision.
Yes,
It said that Ms. Beavers did not meet the criteria.
correct.
For
And was discharged to home. Okay, and that's for outpatient
Okay.
treatment. All right, so what I will do is I'll adjourn this then, so we can figure out. I'll adjourn this to July 16th. And then I'd like a report as to where she is.
Sure.
Okay. All right, her bond will continue at this point.
Thank you.
Thank you. Court does call the case of the people versus Jacqueline Murray.
Connor and Silver on behalf of
Kyle Burrell on behalf of Ms. Murray.
Sorry about that, Your Honor. Assistant Public Defender Natalie Pate on behalf of Ms. Murray, and the case ending in 1190 and anticipating appointment on the case ending 0617.
Your name?
Jacqueline Murray.
All right. I'll start with the new case, 0617. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about May 14, 2025, you were in possession of drug paraphernalia at the location of Harper Road in Pittsfield Township. You understand the nature of that charge, ma'am?
I understand.
All right. It's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Mhm.
Yes?
Yes.
All right. Do you wish to be represented by an attorney?
Yeah.
Public defender case.
Thank you, Your Honor. Assistant Public Defender Natalie Pate again on behalf of Ms. Murray. We would waive any further reading, stand mute, and not ask for a bond at this time, Your Honor. I believe this case will be resolved today.
All right. All right. So what are we doing?
So as to my 2 cases, Your Honor, Mr. Siller has extended an offer in which Ms. Murray was offered to admit responsibility to double parking in the case ending in 1190. And in exchange, the misdemeanor would be dismissed, and that then case ending in 0617 would be dismissed in its entirety. I did discuss that with Ms. Murray, and she would like to accept that offer today.
That is correct, Your Honor.
And what are we doing on the other case?
Your Honor, we are just asking for an adjournment. The people and I are trying to work out a global resolution involving some cases in some other courts.
That's
So we're asking
correct.
for
There's
an
a pending retail fraud as well on 15th. So we're trying to see how it's all going to shake.
And when is that one set for?
I don't recall.
I have to, let me look it up. I don't have it.
I think it's the middle of next month, but I'll know here in a second.
I've got it right here.
Retail fraud is set for retail on June 26th.
Oh, June.
June 26th.
26th. Okay, so
All right.
next week.
So would it still give you enough time if I set this for July 2nd?
I think so, Your Honor.
I'll adjourn this matter then, that being the case ending in 1360, July 2nd, 2025, 9 a.m.
Thanks, Judge.
Bond will continue on that case. In the other case, Ms. Murray, do you admit responsibility to the fact that on or about August 2nd, 2022, at location on Washington Avenue in Pittsfield Township, Washington County, State of Michigan that you double parked a motor vehicle.
Yes.
All right, court will accept that admission. That is in case 1190. That's count two. Count one is dismissed. And also case 167, ending in 167 is also dismissed.
It's 0617.
0617. What did I say? Yeah, okay. Is dismissed. On the double parking, fines and cost of $180. You're incarcerated. What I'll make that do is I'll make that do 90 days after release.
Thank you, Your Honor.
All right.
Thank you.
Judge. Court calls case People versus Nadia Costley.
Right, so around, yeah.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Causley, who should be present via Zoom, standing in for Ms. Perny.
She's not. Both are on, correct? She is not in Zoom.
So, Your Honor, for the record, I'd respectfully request an adjournment. It's my understanding that she has a Secretary of State appointment scheduled for today after court. I don't have a further explanation for her failure to appear and respectfully request an adjournment.
In these matters, bench warrant will issue for defendant's failure to appear. Bond in each case is set in amount of $5,000. Will give a 10% privilege. Both of those warrants will issue immediately.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Caitlin Morgan.
Ashley Lonnie for the people.
Good morning, Assistant Public Defender Lauren Penny on behalf of Miss Morgan, who is approaching.
Your name?
Caitlin Morgan.
This is special time set for sentencing in this case.
Yes, Your Honor.
You know, we did review the pre-sentence report. We have no material changes, additions, or deletions. I did review the recommendation with Miss Morgan and we do ask that you adopt it, and I would like to make a few statements on Miss Morgan's behalf when appropriate.
All right. Just so that we're also clear, did you review, there was a victim's impact letter that was sent. Were you able to review that also, counsel?
Yes, I think there were two original, and then I got an initial one this morning, and I was provided that from the victim's advocate.
All right, very good. And I know that the victim in this case is present. My understanding is she at one point wanted to make a statement. I don't know if this letter is.
Your Honor, I believe that provided she just decided to provide you the statement in writing, so she can.
All right.
That's the understanding of the people as well, Your Honor.
All right, go ahead.
Your Honor, today is a special time for sentencing, and I want to start out by thanking Your Honor, as well as Ms. Pilara, in considering some additional information that I provided to her. It was a 22-page memo, so it was quite lengthy. And again, I do thank her for considering this information. I did want to, again, there was a lot of stuff that's provided on the record, and I do want to focus on some mitigating information on behalf of Ms. Morgan. In December, I first want to address her health. In December 2024, she got into a very serious car accident. She's in the hospital for some time and is still dealing with those repercussions. She's seeing both a neurological doctor for the effects of her nerve damage, and she's had one surgery on her arm and is scheduled to get an additional surgery on that arm. It's not functioning properly, her arm. She does not have full range of motion. She did miss a post-op appointment while she was in custody. And when she gets out of custody, she'll be returning to see that doctor. She is trying to get disability because of that injury, and is engaged in another civil suit because of the crash. Even though she is having that that difficulty with her arm. She is working and engaged in school. This semester she was at Ross Medical Center, studying to be a certified medical assistant. Her plan is to go to nursing school. She was working as a health health aide, excuse me, for an elderly man. Her mother explained to me that she was essentially doing this job with one working arm, but needs to support her children and assist with the man's daily tasks. She is planning on, or is set to graduate from Ross Medical Center with her certification as a certified medical assistant. However, there's one last test she has to take that includes CPR, and because of her arm, she can't do that CPR portion of the test. She is engaged in mental health treatment. She has a psychiatrist that she sees monthly, and she's also engaged with who she's also engaged with talk therapy with. She does have the support of her family. I have been in communication over the last couple of weeks with her mom every couple of days. Her mother submitted a letter on her behalf, as well as her grandparents. Because of her injury, she does need a caretaker. She is moving in with her mother, so her mother can help her with her own daily tasks, as well as the care of her children. She has 3 children, 7, 2, and 1. Her oldest father died when he was young. So she's desperate to, get out of custody and get back to. Oh, she said he died when she was pregnant with the oldest. Given all of this, her engagement in mental health services, her physical health condition, her children, schooling, employment, I am asking the court to adopt this recommendation. She does have the support of her mother, who is here and I think would like to speak to your honor. I've had multiple conversations with Morgan over the last couple of weeks, and I think she's quite desperate to change her life. She's already made some changes in the relationships in her life. And I think she's dedicated to the betterment of herself and her children's lives.
All right, very good. Her mother wanted to address the court.
Yes, if that's okay with your honor.
Where is she? Come on up. Hello.
Hi, Your Honor.
What's
If I
your
may,
name?
just one moment, your honor. It's okay.
I'll try. I'll try.
All right. Your name?
April Moylanen.
All right, go ahead. What would you like to tell?
Your Honor, I'd like to tell you that Caitlin is a good person. She has a good heart. She's active. We are active in 2 churches. We go monthly, feed the homeless down in Cass Park. As a matter of fact, a month before Caitlin's bad accident, we were down in Cass Park handing out hot meals, essentials, clothing, whatever we could do to help the homeless. Caitlin has 3 children, which I'm currently caring for. And it has been a hardship on me because I'm trying to work full time and care for 3 grandchildren. Instead of being the grandmother, I'm being the mother, which Caitlin should be doing. I understand that Caitlin's behavior has gotten her where she is, but Your Honor, this has been going on for 7 years with these 2 baby mama daddy drama. Okay, it's been back and forth, back and forth. I just wish that Caitlin gets herself together and stays away from the negativity. Her kids need her. They cry every day. My grandson wrote a letter to you. I don't know if you got it.
Yeah.
It was pretty sad, to see him, crying for his mom. And it's really hard on me. And I just ask that you find it in your heart to let my daughter come home.
Thank you.
Thank you.
And anything you'd like to tell the court before I impose sentence?
No, Your Honor.
All right. Court has reviewed extensively the information that has been provided and looked it over, and the court does believe and will follow the recommendation of the probation department. In this case, I think it's well suited to kind of deal with a number of different issues that are sort of permeating this entire case. So it's the sense of the court, I will place you on 36 months probation. That's 3 years. You are to pay $655 fines and court costs, $1,080 probation oversight fees. That will be on a payment plan as arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the life skills program. You're to enroll in that within the next 60 days. You are to attend individual therapy with status reports to probation. There is to be no contact with Sarah Tessier or her children directly or indirectly. You understand that, ma'am?
Yes, Your Honor.
There is to be no use of social media whatsoever. Delete and or close all accounts on social media immediately upon your release. You understand that?
Can I ask one question? I have one page where I'm friends with my son's dad, and that's the only way I can see pictures of him and show my son. Is that okay if I just
See
keep
pictures of
his father, who's deceased?
Yeah, I think if it's okay, Ms. Pilar and I can work something out.
regarding that. I'm gonna order that, so, because I think there's been an abuse of that, and so I am gonna order that her social media accounts are to be closed and deleted. All right. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to comply with any and all circuit court orders if there are any. You are to contact probation within 24 hours of your release from custody and then report as directed by probation. I am going to order a GPS tether through community corrections with the exclusion zone. Are you indicating exclusion zone of the entirety of Washington?
Yes, Your Honor.
All right, with the exclusion zone of Washington County. I'll schedule a review hearing on this matter for August 27th, 2025 at 12 p.m. I will order 365 days in jail. Credit 17 days that you served. You're to serve an additional 14 days for the bond violations to date, and then the balance will be suspended with placement of a GPS tether as indicated prior to your release.
Yeah, I'm sorry, I should have brought this up before, regarding the exclusion zone, and again, this is something that Ms. Pilar and I can work out. Her doctors, like her orthopedic surgeon is at Trinity Health in Ipsy, so we can, if the court's amenable to that, and Ms. Pilar, I can provide documentation regarding medical appointment.
Yeah, correct, and for medical, that's where her medical appointments are, that will be allowed. All right, but strictly for that medical or any other necessity that she has to have within Washington County, as she would be able to report to probation.
Correct, understood, thank you.
All right, thank you. Court does call the case People versus Christopher Minor.
Conrad Solon, we got Eastville Township.
National Line for people.
Good morning, Assistant Public Defender Laura Kearney on behalf of Mr. Minor. Your Honor, I did attempt to make contact with Mr. Minor. I was unable to make contact.
Oh, those two separate groups there. Ma'am? All right, I'm gonna have you're with Miss Morgan, correct? You're with Mom and everybody. I'm gonna have you wait to let the others go.
Okay.
And then, okay, thank you.
Thank you.
All right, go ahead. I'm sorry on the minor matter.
No, I apologize. I was not aware of what was happening behind me, but yeah, I attempted to make contact with Mr. Minor multiple times. I have not heard back from him. I did speak with the CMH caseworker yesterday who indicated he did call her yesterday. So it seems like he is engaged with services, but not present.
Bench warrants will issue for defendant's failure to appear in all of these matters. Bond is set in the amount of $5,000. 10% privilege. Those warrants will issue immediately. Thank you. Court does call the case of the People versus Anton Brooks.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Brooks, who stands to my right. Please state your name for the record, sir.
Tom Brooks.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Brooks will be accepting the offer of Mr. Siller of pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed. I did go over Mr. Brooks's advice of rights form with him yesterday in the jail, and he is now signing right there.
So Your Honor, operating, allowing an ineligible person to operate MCL 257.326. You thank you legally and be dismissed.
May I have it sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir.
State your name.
I'm Tom Brooks.
Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail and or a $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding that you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed any advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right? I didn't say so.
Yes, sir.
Are you on probation or parole?
Yes, sir.
You are?
Probation.
Probation? Were you on probation at the time of this offense?
Yes,
In
sir.
April?
Yes, sir.
All right, I do have to advise you, then your plea could be a violation of that probation. You understand that?
Sir.
If it is considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Yes, sir.
Understanding that, you still wish to plead guilty to these charges?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
Yes?
Sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 6, 2025, the location of Washtenaw near Gulfside, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes, sir.
All right. You understand also, sir, that if I do accept your plea, and again, I'll be immediately sentencing you, so there would not be a period in time between acceptance of the plea and that, but if there were misconduct, you would not be able to withdraw your plea, and any agreement with the court or any evaluation by the court, the court would no longer be bound by that. You
Yes, sir.
understand that, sir?
Yes, sir.
All right. Counsel, had there been any other threats, promises, or other inducements that have led to this plea?
No.
Not that I'm aware of, Your Honor.
All right. Has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Anything either of you want to say before I impose sentence?
Just briefly, Your Honor, we'll note that Mr. Brooks has, I believe as of today, 34 days of credit. So I would ask the court would consider sentencing him to a credit for time served sentence. He is being held on other matters with his next court date being the 26th of this month.
Sir, anything you want to tell me?
No, sir.
Fines and costs of $250 that will be due and payable 90 days after release. Other than 90 days in jail, credit 34, balance suspended. Thank you.
Thank you, Your Honor.
Court does call the case People versus Brendan Williams.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Williams, who should be present via Zoom.
And absolutely good people.
Mr. Williams, state your name, please.
Brendan Williams.
Thank you. 578 is annoying. Got it. All right. Before we go on to the other case, sir, you have a new case before the court that alleges that on or about April 3rd, 2025, at the location 5915 West Michigan Avenue in Pittsfield Township, that you did operate a motor vehicle with a high blood alcohol content. Do you understand the nature of that charge, sir?
Yes.
That is a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service, any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
I would also indicate that there is a second offense notice so that the penalties on this would be increased to a misdemeanor punishable by up to 1 year incarceration and a fine of up to $1,000. You understand that, sir?
Yes.
First question I have for you, sir, is do you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Natalie Pate, again, on behalf of Mr. Williams, we waive any further formal reading, stand mute, and ask for an adjourned pretrial date in this case, Your Honor, please.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. As to bond in this case, alleged BAC.
0.294. And I will note for the record as well, Your Honor, the court noted the incident date of April of 2025. The prior conviction date is October of 2024. The arrest date for that case was August of 2024. So extremely close in time. I am requesting a scram tether.
Was there any accident?
There was not a crash. The defendant was located laying sideways in the front seat of the vehicle and was making comments about he should be in the driver's seat, things of that nature. There was not, but there was no crash.
All right. As to bond.
As to bond, Your Honor, I would request a PR bond, and we have no objection to any of this standard bond conditions. I just want to note that Mr. Williams does currently have a scram tether on him for his probation that he was sentenced to last week through 14A1. And so he does currently physically have a scram tether on him. We certainly.
Was that going to expire at some point?
I looked at the sentence and it didn't have it written on there when it would. I would speculate that it would expire at some point. Yes, I don't have that date of when that is, though.
All right.
And Your Honor, if I recall correctly, I do believe that's a case that also had a drug and disorderly charge attached to it. So alcohol does seem to be a major problem.
Set his bond in that case at a $30,000 personal recognizance bond, all order standard conditions, including no assault behavior or possession of any weapons. There is to be no alcohol, recreational marijuana, or illegal drug use by you. I will sign a community corrections order for a scram tether that one would be placed after expiration of the current order on the other matter. All right. What are you doing in the other case?
Your Honor, regarding the other case, I'm moving as the defendant's conduct does not satisfy the elements of the offense.
On the disorderly person?
I'm a disorderly person, correct?
Any objection?
No objection, Your Honor.
That case, that being case 0546, that case is dismissed. All right, we'll see him on the second.
Thank you, Your Honor. And thank you, Mr. Williams. You're all set for today, but we'll be in touch for the next time.
All right, thank you.
Court does call the case of the people versus Matthew Vanessa. Fonseca. I think is how it is.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Fonseca? State your name, please.
Matthew Fonseca.
Thank you.
Your Honor, we're asking for an adjournment in this case. Mr. Fonseca has a PCC before Your Honor on the 26th. I was in communication with Ms. Londi this morning as well, and I'd like to relay some things to my client about possible resolution of this case. So, and of course, the felony may drive the bus depending on what happens there. So we're just asking for an adjournment.
July 2nd, 2025.
Thank you.
Thank you.
Thanks. Have a good one.
How many are in my 11 o'clock? You can put them up there. I'll start rolling them. I mean, we can actually start calling some in between cities.
Yeah.
Or while they're still part of the same lot. So if I got one that I can call.
Yes. So this one is ready. He's gonna call.
Court does call the case of the people versus Gabriela, is it Herrera?
Christina Bergeron for the people.
Good morning, Your Honor. Tina Saxon on behalf of Ms. Herrera, who's approaching. What's the name? Gabriela Herrera.
What are we doing?
Your Honor, today's day and time for a PCC. My client is
No, it's
willing to enter.
It's for a pretrial.
I'm sorry, pretrial felony mode again. My client's interested in entering a plea, and in discussion with the prosecutor, it would be pleading as charged with HIDA.
HIDA.
That's correct, Your Honor. The offer is to plead guilty to charge of HIDA.
Thank you. Sever sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Gabriela Herrera.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of embezzlement by an agent or trustee less than 200, I think it is. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Understanding that you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are the rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Sure.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? Yes?
Yes.
Between the dates of May 27, 2020, August 10, 2022, at the location of 7,000 East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you employed at Walmart?
Yes.
All right. And what'd you do that makes you think that you're guilty of this offense?
I was working there and I took several items while on the job.
You took several items like what?
Without paying for them.
Okay.
Yeah.
So You took items during that period in time from the job. You did not pay for those, correct? You didn't have anybody's permission from Walmart to do that.
No.
That was not some benefit of your employment that
No.
you take that, build
No.
that property. This property you took, was it valued in excess of $200?
No, it was under that.
Okay. And you came into possession of this property that you took by virtue of the fact that you were employed at Walmart? Yes. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred, before I say that, I guess I do have to advise you of this. If you understand that if I accept your plea, ma'am, if between now and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that any sentence agreement or any evaluation like for HIDA or other things would no longer be in play and the court is not bound by that. You understand that?
Yes.
You understand also that if you do commit that misconduct, you would also not be entitled to withdraw your plea.
Yes.
All right. And counsel, is counsel aware of any promises, threats, or other inducements that have made this plea come about other than those that may have been disclosed on the record?
No, Your Honor.
No, Your Honor.
All right. Thank you. Court will accept the defendant's plea then of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th at 2025 at 12 p.m.
July 30th, 2025, 12 p.m. All right.
Your Honor, I'm sorry, I'd like to add for the record that the prosecution consents to HIDA in this case as the defendant was 23 years old at the time.
Got it. Okay. Thank you. All right.
Thank you.
Thank you. Court does call the case People versus Darrell Frederick. All four cases.
Conrad Stone on behalf of the student township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, who stands to my right. Please state your name for the record, sir.
Darrell Frederick.
All right. What are we doing?
Thank you, Your Honor. There is a resolution in all four matters to which Mr. Frederick will be pleading no contest as charged in the case that ends in 1042. And in exchange, all other three cases will be dismissed. Sorry, Your Honor.
Go ahead. Go ahead.
I have reviewed Mr. Frederick's advice of rights with him in the jail yesterday.
He's
And he
pleading
is
no
signing.
contest in the case ending in 1042 and the others are being dismissed.
Correct, Your Honor.
Yeah. It's the one that came in. All right. Yeah, that's all. All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Darrell Frederick.
Sir, it is this court understanding you're going to be pleading no contest to the charge of retail fraud under the Pittsfield Township ordinance. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
I do, yeah.
Do you understand what a no contest plea is?
Yes, sir.
Two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability.
Sir, to that charge, how do you plead?
You plead no contest, guilty or not guilty.
No contact?
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes,
of your own free will.
that's correct.
And because, well, I won't ask you that. Counsel, the court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 247634. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Sir, I do have to also advise you that if I accept your no contest plea between the time of today's date or its acceptance and the time of sentencing, if you commit misconduct as defined by the court rule, that any sentence agreement or sentence evaluation would no longer bind the court. You understand that? I wouldn't be bound by that. You understand that, sir?
I do, Your Honor.
You understand also that if you commit any misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, is counsel aware of any other promises, threats, or inducements which have resulted in this plea?
No, Your Honor.
No, Your Honor.
All right. And based upon a review of the police report in this case, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea of no contest to this charge. The case is ending in 0671, 0944, and 1267, all 2024 cases. Those matters are dismissed pursuant to the plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
July 7th, no,
July 9th.
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. Fine, we'll continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Adams. Swords.
Ashley Lundy for the people.
Good morning, Your Honor. Timothy Dinan, P49499, appearing on behalf of Mr. Sowards, who's also present on Zoom today.
Sir, please state your name.
Adam Swords.
All right, what are we doing?
Your Honor, I have received some of the discovery. I'm still waiting for the police report. I've just asked for an adjournment and have this matter set for another pretrial, please.
Adjourn the matter to July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue.
Bye-bye.
Bye-bye. Court does call the case of the People versus Justin Goltowski.
Christina Bertrand for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Goltowski, who should be present via Zoom.
Goltowski, I don't have him.
So, Your Honor, I don't have an explanation for his failure to appear. We actually spoke yesterday and we had a scheduled appointment for Friday at 2 to further review his discovery and options. I did provide him with a Zoom link and was expecting him to be here today. I would respectfully request an adjournment for the record.
Bench warrant will issue for defendant's failure to appear, bond 5,000, 10%. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case of the People versus Stephen Grisbeck.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Grisbeck, who is approaching. Please state your name for the record.
Stephen Grisbeck.
Your Honor, Mr. Grisbeck is going to be pleading guilty as charged. We will be asking for immediate sentencing. He has 84 days credit as of today.
He has 84 days.
Yes.
I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Stephen Grisbeck.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of possession of drug paraphernalia. Is that correct?
Yes, Your Honor.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You cited advice of rights form.
May I approach?
Yes, I do.
Any question regarding any of those rights?
Oh, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
Yes?
Yes, Your Honor.
All right. You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
To clarify, Mr. Grisbeck is on probation before Your Honor, but
Yes, he
this
is.
incident
Yeah.
occurred before he was on probation.
Yes. Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
All right. I do have to advise you, although I'm likely to impose immediate sentence, that if you commit misconduct between the time of this plea and the time of my sentence, that you would not, first of all, be allowed to withdraw your plea, and that any potential sentence agreement and or evaluation would no longer bind the court. You understand that?
Yes, Your Honor.
All right. So, sir, on the date of September 3rd, 2024, at the location of Packard Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have drug paraphernalia in your possession?
Yes, Your Honor.
What'd you have?
A syringe.
All right. And you used that for the taking of drugs?
Yes, Your Honor.
All right. Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Sir, anything you want to say before I impose sentence?
Not this time, Your Honor.
Anything, Ms. Farney?
No, Your Honor, as I stated, we would ask for credit for time served. He has 84 days of credit in the Washtenaw County Jail. And when he's released from here, he will be on probation before Your Honor in Ms. Pilara.
This is last case before me.
I think so, yep.
Been showing up forever.
I'll see you again on July 7th.
So no.
He's back.
He's back.
Just
All
for
right.
probation review, though.
All
It's
right, okay. but-
not a nude case, so.
All right. Sent to the court. State minimums of $125. I will then sentence him to 84 days, Washtenaw County Jail, credit 84, sir. All right.
All right, thank you.
You're up.
Thank you.
Court calls the case of the people versus Lamar Hampton.
Ashalani for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Hampton.
Mr. Hampton,
Lamar
can you state
Hampton.
your name, please? Thank you.
Lamar Hampton.
Your Honor, I am requesting an adjournment of the pretrial hearing, and Mr. Hampton will read over some documentation regarding his efforts towards getting his license, and I would like to have another conversation with the people.
July 2nd, 2025, 9 a.m. Thank you, Mr. Hampton. Court does call the case of the people versus Roman Hop.
Christina Bergeron for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Hop. Please state your name.
Herman Hop.
Who will make sure that he has full pants on when he comes here again.
All right.
We'll have a conversation about pants, Your Honor.
All right, what are we doing?
We're asking you to set this for final settlement, please.
Jury final settlement conference will be August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in.
Thank you.
Court does call the case people versus Otis Elliott.
Christina Bergeron for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Elliott. And Your Honor, I did attempt to contact Mr. Elliott. I didn't hear back from him. I'm not sure. Was he in present in the courtroom? I'm not sure if he's on Zoom.
He is not.
I do not have a explanation for his failure to appear for the record. I request an adjournment of this pretrial.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately. Who? They're coming here right now. Court calls case People versus Ariana Jenkins.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Jenkins, who stands to my right. Please state your name for the record, ma'am.
Ariana Jenkins.
Thank you, Your Honor. Today, we're here for both a bond violation and a pretrial. As to the pretrial, well, I'm happy to address whatever, Your Honor.
Go ahead.
So as to the pretrial, I'm just requesting a very brief adjournment. The people have extended an offer of this case for my client to plead to an added count 2 of operating while intoxicated. I was able to briefly discuss that with her. However, we need more time to discuss both the ramifications of that potential resolution. So I would be asking for a very brief adjournment. And I am also prepared to address the bond violation when appropriate.
Turn it to July 2nd, 2025. As to the bond violation.
Thank you, Your Honor. As to the alleged bond violation, which is that Ms. Jenkins did not report to Community Corrections to obtain her SoberLink device, I have discussed that with her and she does admit to that bond violation. She did turn herself in yesterday at 2142 to the Washtenaw County Jail on this warrant on my advice to do so. We are asking that the court would release her today. She does understand that if she were to be released, she would have to, it is likely that a community corrections re-referral will be ordered and that it is likely that that may be a scram tether at this time. She does understand that she would likely be fitted with that before her release from the jail. I am asking that the court release her. She does have strong ties to this community. She does live in Saline with her mother, her cousin, and her grandma. She has full-time plus employment, working 6 days a week at a senior residential living / nursing home. In speaking to my client and upon what I can access, it is my understanding she has no prior criminal convictions and no other pending matters. She has strong family support. Frankly, I asked her when I received this bond violation and was in contact with her, I asked her why she did not go to pick up the SoberLink. She did state to me that she went to the court clowner, was told that it might take a couple hours for the SoberLink to be ready after the order was provided. And she was in fear of losing her job if she didn't show up in time to her shift. So she left and went to work. I did advise her that candidly, she should not have done that. She should have waited and complied with this court's orders. My client does understand that, and she does understand that this is a very, very serious matter. After the bond violation was issued, she was in both contact with me and then on her own did submit a bench warrant recall. Since this, we've had many conversations. She did turn herself in on the warrant yesterday. She takes these court orders seriously. She just wants to apologize to the court and ask for another chance. It is my understanding that there is no drinking events and that there are no other alleged violations.
Grant her a personal recognizance bond with a teller prior to release.
Thank you, Your Honor.
Thank you.
Thank you.
Second.
Thank you, Your Honor.
Yes, so get her on it. Court does call the case People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Fox.
Ms. Fox, can you state your name, please?
Jessica Fox.
Your Honor, we're requesting an adjournment. Lonnie and I did have a conversation this morning about this case. I just want you a little time to speak to my client.
July 2nd, 2025, 9 a.m.
I'm going to call you, Ms. Fox. Thank you, Your Honor.
All right, thank you.
Court calls case People versus Marcus Moore Jones.
I didn't get the Zoom information, that's why I'm here.
What?
I didn't get the Zoom information, that's why I'm here.
What's your name?
Absolutely.
Okay, you can be here. Come on up. Is that because you're wearing shorts? You didn't want to come up?
No, I kind of woke up late today. I thought I was gonna miss court. Not gonna lie, Judge Simpson. I woke up and came straight here.
And had no pants?
Nope, this is exactly what I had on, except for the shoes. But
No, we won't let that happen next time, right?
yes, sir.
All right. Mr. Moore Jones, you are before the court on a misdemeanor citation that alleges that you did operate a motor vehicle without proper security or insurance. That is alleged to have occurred April 29th, 2025, US 23 in Pittsfield Township. You understand the nature of that charge, sir?
Yes, Your Honor.
That's a misdemeanor punishable by up to 90 days, a minimum of $200 and up to a $500 fine plus court costs. You understand that?
Yes, Your Honor.
First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
It's a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Moore Jones, we would waive any further reading, stand mute, and ask for an adjourned pretrial date.
Retrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. You think you can make that time?
Yes, Your
You
Honor.
ain't going oversleep?
No,
You sure?
no, I'm not going over sleep.
All right, well, if we do, I got your address. We'll come get
All right,
you.
I know that for sure.
Send in every way for a reading, standing mute, equivalent or not guilty plea. July 2nd, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. I will also order that there's to be no use of alcohol, recreational marijuana, or any illegal.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Oh, sir.
No.
Court does call the case of People versus Chad Jones.
Conrad Soder on behalf of Pittsfield Township.
People.
I have 3 cases.
Sorry. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Chad Jones.
As Your Honor knows, Mr. Jones has felonies before Your Honor at the PCC stage. Everyone's working to get him into treatment, so we're requesting an adjournment for that and also work something out.
So his felony cases, we adjourned to what day?
July 3rd?
July
3rd.
3rd. Okay. Well, dear, doesn't do any good to put these on the 2nd then.
Probably not.
So I'll adjourn these all then to July 16th, 2025 at 9 a.m. And if we get a resolution, have to do something, we'll try to deal with these early. Yeah. All right.
Thank you.
Thank you, Mr. Jones. Bond continue. It does call the case of the People versus Pauline Macharia.
Assistant Public Defender Natalie Pate with and on behalf of Macharia, who is present via Zoom. Ma'am, can you please state your name for the record?
Pauline Machare.
All right. What are we doing?
I have discussed this matter with Miss Londi. It was my understanding that this case was going to be dismissed.
Crickets.
Sorry, Your Honor, I'm so sorry. My notes are on a slow bus from Detroit. It's
Whoa.
a long time.
Wow.
Thank you, Alan. Yes, this case will be dismissed. Thank you.
All right.
Get the paperwork over.
Case is dismissed without objection.
Yes,
All
there's
right.
no objection.
Thank you, ma'am.
Thank you.
Thank you, ma'am. You're all set.
All right, thank you, ma'am.
Court calls the case People versus Todd Reberg.
Conrad Soder on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Reber. Mr. Reber, please state your name for the record.
Todd Brian Rayberg.
Your Honor, we are requesting an adjournment of the pretrial. I do have an order for the court to consider releasing him to treatment. He was before Your Honor yesterday, and
Yes.
I believe Your Honor signed that.
When did we adjourn your case yesterday to?
Third.
Third, okay.
Order courtesy of Ms. Yagi.
Pardon?
The order's courtesy of Ms. Yagi.
I know that. I'm glad
So
you finally have talked to her and listened to her.
I know it's
Trying to get the others to do the same.
a pretty nice order.
It's a beautiful order,
So that's our
done
only.
correctly. Not something I expected from your office. Go ahead.
Dang, catching.
Wow, that was a shot.
That wasn't even a stray. That was a direct hit. So that's our only request. Well, I guess both requests an adjournment and the order to be released.
All right. And again, you're looking at some type of global resolution ultimately.
Right. This is a possession of drug paraphernalia case. So the standing offer from Mr. Sillish dismiss if treatment's completed, and he has felonies, multiple felonies or one felony.
And Your Honor, he does have 2 drug paraphernalia cases in this court. That's why his case is 0195.
Oh, that's correct. It is set on July 2nd.
The other case.
Yeah.
Okay. Then. Well, why don't I just put this on July 2nd, understanding we might have to adjourn it, but then everything will be together.
Yeah.
And he may get out on this.
Yeah. Thank you, Your Honor.
All right, thank you. Thank you, Mr. Wood.
Thank you.
Court does call the case People versus Chad Maurer.
Epsilon for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Maurer. I'm not sure if he's on Zoom.
Chad Maurer. He's there, but he's not.
Hey, there we are.
State your name, sir.
Chad Maurer.
Okay.
Your Honor, I'm requesting an adjournment. Mr. Maurer and I did not have a chance to connect prior to today's hearing. His mom did inform me, though, he started a new job, and that's likely why he's been working a lot, and that's likely why we have missed each other. So I just like a chance to speak to him about resolving this file.
July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Maurer.
Yep.
Court does call the case of the People versus, is it Aneja O'Hearn? O'Hearn,
Epsilon for the people.
this arraignment. Court will issue an order to show cause for their failure to appear. Court does call the case of the People versus Brandon Smith.
Conrad Stone on behalf of Pittsfield Township.
This is an arraignment.
Yes, I'm sorry.
You know what, Your Honor, I'll make it easy. I'm going
Okay.
to dismiss. Defendant's conduct does not satisfy the elements.
Sir, you have any objection to that?
I do not, Your Honor.
I didn't think. You did. All right, case dismissed.
Thank you,
Take
Your
care
Honor.
of yourself.
Thanks, sir.
Court calls the case People versus Rebecca Miller.
Epsilon for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who appears via Zoom. Ma'am, can you please state your name for the record?
Rebecca Miller.
Thank you, Your Honor. So fortunately, Ms. Miller is back at Dawn Farm, no longer at the hospital. So today we can do the resolution that we intended to do at the last pretrial before Ms. Miller was unfortunately had emergency surgery. I do have a plea form here, and Your Honor should be in receipt of the police report as well as signed advice of rights form that I submitted prior to the last pretrial.
I don't know that I still have the police report in the file.
The offer that was produced to writing in front of you is to plead to that add count 2 of retail fraud in the 3rd degree, dismiss count 1 retail fraud in the 2nd degree.
All right. We have a report.
I'm sorry, I should have submitted it again probably or
Yeah.
twice. I didn't.
All right.
I didn't know if it was kept.
Ms.
in file or
Miller,
not.
we'll come right back to you. Let me pass this matter briefly. I'm sure I reviewed the report. I just don't have it in front of me. Okay. Court to pass that case. Court does call the case People versus Leo Stringa.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stringa, who is approaching.
Your name, sir?
Leo Stringa.
All right, what are we doing?
Thank you, Your Honor. This is the first pretrial in this case. I'm respectfully requesting an adjournment to, well, first of all, fully discuss this with my client as well as in tandem with his other matters. He's scheduled for his next court date on July 3rd. I believe it's a probable cause conference on his new felony retail fraud case. I would request an adjournment possibly till after that date, if Your Honor would allow.
July 16, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Kenneth Miller.
Dr. Lonnie for the people.
No cause of failing to hear the arraignment pretrial, he is in Zoom.
Kenneth Miller.
Kenneth Miller.
Sir, you are before the court on a misdemeanor complaint that alleges that on or about March 19, 2025, at the location of 7,000 East Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, you did operate a motor vehicle while intoxicated with an occupant less than 16 in that vehicle. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That is a misdemeanor punishable by a fine between $200 to $1,000, not more than 1 year in jail. The court could order community service as well as any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right, first question I have for you is, do you want to be represented by an attorney?
Yes, please.
It's a public defender case.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Miller. We would waive formal reading and stand mute for the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to these charges. You're asking for an adjournment?
Yes, Your Honor.
I will adjourn this to July 2nd, 2025, 9 a.m. As to bond.
Your Honor, in this case, the defendant, as charged, did have a person under 16 in the vehicle. I do believe that was his 6-year-old child. There was a crash, and his alleged BAC is 0.210. I am requesting a scram tether.
Your Honor, I'd ask for a personal bond. I think a scram tether is reasonable request.
Bond in this case will be set in the amount of $20,000 personal recognizance under standard conditions, including no assaultive behavior or possession of any weapons. There is to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand all of that, sir?
Yes, Your Honor. I have one question about is the scram tether, is that an alcohol tether or a GPS tether?
That's well, it has GPS capabilities, but it is an alcohol tether.
Okay.
I'm going to order that you report over to the Department of Community Corrections for placement on a scram tether. You need to do that within the next 24 hours, sir.
Yes, Your Honor.
All right. Thank you.
Thank you.
Next date was 7/2, Your Honor.
Yes.
Thank you.
Court does call the case People versus Shania Williams.
Conrad Solar on behalf of Pittsfield Township.
Afternoon. Assistant Public Defender Lauren Kearney on behalf of Ms. Williams. Okay, please. Your Honor, I did attempt to make contact
Did
with.
your computer get on the same bus as Ms. Lonnie?
Yeah, it was, and maybe my brain as well. Hi, good morning. I didn't have contact with Miss Williams. I did not realize you were in custody, so I apologize. This is a licensed case. Are you being held on other cases, I presume?
Yes, ma'am.
Okay, so I would just ask for an adjournment of this case.
July 2nd, 2025, 9 a.m.
Thank you.
And I don't know if you stated your name for the record. Can you state your name, ma'am?
Shania Williams.
Thank you. All right. Thank you. Yeah.
And the problem, okay, yeah, I'll come.
I did not start anything on this. Court recalls case People versus Miller.
Rebecca?
Yes, Rebecca Miller.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller. Ma'am, could you please state your name for the record?
Rebecca Miller.
Court's understand, she's gonna plead no contest to the charge of retail fraud in third degree. Upon their successful no contest plea to that charge, count one would be dismissed. That's the court's full understanding of the.
Correct. Yes, Your Honor. And that is my understanding as well as my clients that we have discussed, and she would like to accept that offer, pleading no contest today.
Ma'am, can you please raise your right hand?
Sorry.
You solemnly swear or affirm testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. State your name again for the record, please, ma'am.
Rebecca Miller.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure you understand. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Correct, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Correct.
You had previously signed an advice of rights form, is that correct?
Yes, Your Honor.
All right. Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including those contained in paragraph 5 on that form, which are your trial rights. You understand that?
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
They have not.
You're doing this voluntarily and of your own free will?
I am, Your Honor.
All right. The court had previously been provided and has again been provided Pittsfield Township Department of Public Safety report for their case number 2414501. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Ma'am, I do have to advise you that if I accept your plea, if you commit a misconduct between the time of this plea and sentencing, that any sentence evaluation or any agreement regarding sentencing, the court would not be bound by. You understand that?
Absolutely.
All right. I also have to advise you that if you do that, you are also not entitled to withdraw your plea. You understand that, ma'am?
I do, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed, I should say, and I need to ask counsel, were there any other promises, threats, or other inducements which led to this plea?
Not that I'm aware of, Your Honor.
None that I know of, Your Honor.
All right. Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th, 2025
July 30th, 2025, 12 noon. Okay, and are they on? Yes, they are. All right, Ms. Miller, Bond will continue. I'll ask you to wait on the line. We're gonna put you into a breakout room with our probation department to start that intake process, okay?
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Ms. Miller.
Court does call the case, People versus Rick Artuso. 3 cases.
Good afternoon, Your Honor. May it please Honorable Clerk, urge somebody up to Artuso.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Rick Artuso in the cases ending in 1657 and 1656. State your name for the record, sir.
Rick Artuso. Thank you. What are we doing?
Your Honor, there are felony matters that are pending at Circuit Court, which we're looking toward resolution of the case. I'm just suggest we adjourn this matter pending resolution of those cases.
And I did discuss Mr. Artuso's options with him. He stated to me he did not want to adjourn at this time, these 2 cases. However, there are no current offers. I would be requesting an adjournment to join to follow Mr. Burgess' case.
You've got other cases up there?
Yes,
sir.
Your Honor. Sorry.
Right.
Yes.
In Circuit Court?
Yes.
Okay, you understand the reason they're asking for the adjournment? I understand you don't want it, but you're not gonna be going anywhere and they're trying to get all of your stuff resolved.
Oh, okay.
You follow that?
Yeah.
Okay. It makes sense to do that. Do we know when your other cases are set up in Circuit?
The second.
Yeah, pre-trials on
July 2nd?
second. Yep.
July 2nd. Okay. So that would be the same date I'd adjourn these, but those are gonna be at 1:30. I'd be hearing them before then. So here's what I'm gonna do, sir, and if we gotta do something different, I'm gonna adjourn these to July 16th, 2025 at 9 a.m. And if we have to figure out something before then, we'll do that so that you can be heard. Okay?
Okay.
All right. Thank you.
Thank you, Your Honor.
Your Honor.
Ayes. 14A District Court for County of Washington, State of Michigan, is now back in session. Judge Jay Cedric Simpson presides.
May be seated. This is my recall. Court recalls the case, People versus Ryan Couch.
Conrad Silver on behalf of
Assistant Public Defender Natalie Pate for Mr. Gouch, who, Your Honor, Mr. Siller and I have discussed this matter, and Mr. Siller stated he would be dismissing this case.
That's right, Your Honor. I reviewed the documentation. I'm going to move this case.
And certainly no objection to that, Your Honor.
And he left.
He did.
Okay.
But his dad did stay.
Yes.
Oh, his dad?
Stayed, so yes.
So the defendant left, dad stayed.
Dad stayed to make sure everything was
Just
good.
made sure everything, that's just like a kid. They just walk out, parents are left to clean it up. But anyway, thank you for staying, sir. This case is dismissed on prosecution.
Thank you, Your Honor.
Thank you. Take care. Court does call the case, People versus Daniel Nuggles.
Conrad Silver on behalf of Pittsburgh.
I'm here,
Good
sir.
afternoon, Your Honor. For the record, Brendan Dabalski appearing on behalf of Daniel Nago, who's present via Zoom. Your Honor, today is the date and time set for a pretrial in this matter. That being said, I've spoken to Mr. Siller and he's indicated that he's willing to offer my client operating while visibly impaired, which he would like to accept. Is that correct, Mr. Nago?
Yes, sir.
That is correct, Your Honor. So I moved at count 2 of operating while visibly impaired. If you accept that guilty plea, I move to dismiss the original charge.
Yes, sir.
All right. All right, sir, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Daniel Nagel.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
Understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
January 2nd, 2025, at the location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
Do you recall what you had and how much?
I don't know. I mean, a couple drinks. I had whiskey at home.
Were you stopped by the police or was there an accident?
I was stopped by the police, sir.
Why'd they stop you?
I was told that it was because they had a call placed.
Okay. A call placed that talked about some erratic driving on your part?
Yes, sir.
Are you disputing the right of the police in this instance to stop you?
No, sir.
All right. Were you arrested?
Yes, sir.
Were you taken to the hospital for a blood draw?
Yes, sir.
All right. Do you recall what the results of that blood draw were?
I'm not positive.
Results were
3-1-2, Your Honor.
1-2-1, Your Honor.
1-2-1?
Yes.
All right. Sir, do you have any reason to dispute those blood test results?
No, sir.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. Sir, you understand that if I accept your plea and you commit a misconduct as defined by the Michigan court rules prior to sentencing, that any agreement or evaluation of your case regarding sentencing would no longer bind the court to any particular sentence. You understand that, sir?
Yes, sir.
You also understand that if you commit misconduct, you would not be entitled to set aside your plea in this case.
Yes, sir.
All right. Counsel, are you aware of any promises, threats, or other inducements that have led to this plea? other than anything that's been said on the record?
No,
Your
Your
Honor.
Honor.
All right. And counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 30th, 2025 at 12 noon.
July 30th, 2025. What time? 12? 12 noon. All right.
Thank you, Your Honor.
Bond will continue. Sir, I'll need you to hang
Yes, sir.
on the line. I'm going to put you into a breakout room with our probation intake so we can get this process started, okay?
Okay,
All right, thank you.
Thank you, Your Honor.
thank you.
Oh, my goodness.
I just. Well, I was coming to promote, I'm the AGM of DWC, and I seen that I got an order from the dog back a month ago. I see that you guys might do some catering. And I'd love to cook for you.
Come here. No,
Make it
no.
nice and right for you.
Come right up to the podium.
So, yeah.
State your name. No, right.
Oh.
He'll take you
Just
down.
send me Murdoch.
How are you doing?
I'm wonderful.
Are you?
Yeah.
So you came up here, why?
Well, something put it on my heart. Well, my boss, he was like, I want you to promote, DWC. And I was like, okay. And some said, go to the jail. This was a part of my life for 20 years. And I changed my life. 4 years not to drink and 4 years no trouble. So
You kidding me?
yeah,
4 years?
4 years next month.
God,
Not a slip or dip.
God bless you.
Yeah, no. So God has truly been good.
I remember when we first met.
And what? My cocky self. And you
Huh?
got me together.
What?
I was cocky.
You think you were?
No, I know.
How'd that work out with you and me?
You
in that-
nothing to play with.
What?
You know that. Well, everybody know that.
What did I do?
Nothing. You put me in my place.
I did that?
Well, you have to. You have a job to do, right? You have a job to do.
Well, I have a job to do, and you just thought you knew better than me, right?
No, you do your job better than anybody can do.
Well, thank you for saying that. But you thought you knew better than me.
But no, I was cocky because I just recently got sober at that time. And I don't even remember the incident that happened, So I was cocky.
But you're doing well.
Man, so good. My brother passed on Memorial Day. He was 50.
I'm sorry.
But I'm able to be here for his kids in a present mind where nobody else is sober like me. So yeah.
That's fantastic.
Thanks,
Yeah,
Jeff.
let her come on up. You better be
What's
careful
up?
because he.
Mr. Allen knows me real well. Thank you.
All
Coach
right.
Allen. I used to flirt with him even though I was gay. Nice looking and cocky. Something to look at.
Oh, wow. Man.
All
All I know. That was a classic.
You never know what it's gonna happen.
I just
Never know.
hope Felicia was tuned in. You will have to send her a tape of that. All right.
I think Mr. Allen
You know,
was a little embarrassed.
I'll be honest with you. I didn't know what to expect. That I didn't. I didn't expect that.
Poor Mr. Allen. I don't feel too bad for him. Objectified all the time. And look,
Courthouse case, people versus James Raggett.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Senator Lauren Kearney on behalf of Mr. Raggett. Mr. Raggett, please state your name for the record and turn on your camera.
James Patrick.
Thank you, sir.
Your Honor, today's pretrial. I'm requesting an adjournment. Mr. Raggett is going to be doing an alcohol assessment, and that will give us a little bit insight into a possible reduction.
Okay.
Were you able to contact them, Mr. Raggett?
I was not. I did get the link that you sent, but I haven't had a chance.
Oh, did you hear him?
No.
Or no? You're breaking up there a little bit, sir. What were you saying?
Oh, it seems like he took out his headphones.
Can you hear me now?
Yeah, we can hear you a little bit better. Go ahead. The question was, were you able to get, I think, the assessment set up? Is that what you were talking?
Correct, yes, Your Honor, thank you.
Oh, can you hear us, Mr. Raggett? I don't think he can hear us. Well, here's what I'll do. I'll adjourn it out to July 16th, 2025 at 9 a.m. and then I'll let you, that should give you enough time.
Yeah, whether he did it or not, it's still gonna take a while to get back, so, thank you, Your Honor.
All right. Thank you, Mr. Raggett.
Thank
Bond
you.
continued. Court calls the case People versus Kent Robinson.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Robinson, who is present via Zoom.
Yes, he is.
Sir, can you please state your name for the court?
Kent Robinson.
Thank you, sir.
Thank you, Your Honor. I have discussed this matter with my client, and we're asking for an adjournment so that he can make and keep an appointment with the Secretary of State. He thinks he has an idea generally of what he needs to do, but he still needs to make that appointment.
July 17th, or 16th, I'm sorry, July 16th, 2025, 9 a.m. Where's your invite indicate?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Robinson.
Okay.
Make sure to update me with how the appointment goes. We're all set for today.
Thank you. Have a good one.
You too.
You do the same. Court calls the case of the People versus Bosie Smith.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lawrence Henry on behalf of Mr. Smith. Mr. Smith, please state your name for the record.
Boise Smith.
So, Your Honor, today, Mr. Smith has been trying very hard to get his license. However, it has not come to fruition. Secretary of State just dragged his feet. So he is going to resolve it today, however, with 257.326. So you'll have to keep having to follow every couple of weeks.
So, Your Honor, that is correct. So I move to add count 2 of MCL 257.326. If you accept that guilty plea, I move to dismiss the charge.
All right, very good. Sir, please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. State your name again for the record, please.
Boise Smith.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs. You understand that?
I do.
And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, sir?
Yes, sir. According to the court rules, I do.
All right. And you went through an advice of rights form with your attorney?
I have.
All right. Did you have any question regarding any of those rights?
No, Your Honor.
And you understand that you're waiving those rights you went through?
Yes, Your Honor.
All right. You understand you're giving up your right to appeal of right?
Yes, Your Honor.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Voluntarily of my own free will.
Okay, that was my next question. And also, that's how you know you've been here too much.
You gonna put me
And
on
also
blast like
because-
that?
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
All right. On the date, February 24th, 2023, location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes, Your Honor.
All right. Did you allow someone who was otherwise ineligible to operate that motor vehicle?
I did, Your Honor.
All right. And sir, I do have to advise you that if you do, I'll be sentencing you today, so it really doesn't matter, but that if you commit a misconduct between the time of this plea and the time of sentencing, that you would not be entitled to rely upon any recommendation or evaluation regarding your case. You understand, for purposes of sentencing, you understand that, sir?
Yes, Your Honor.
And you also understand that if you commit that misconduct, you could not withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements that led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
All right, court will accept the defendant's plea to count two. Count one is dismissed. Sir, anything you or your attorney want to say before I impose sentence?
No, Your Honor.
All right. Fines and costs of $250, and I'll suspend 90 days in jail. When can you pay the $250?
I can start making payments by next month. I don't want to so much obligate myself to a particular fee starting next month, but I will be able to make at least a $30 down payment on that ticket, and whatever extra money I get.
How long do you think it's going to take you to pay this, Mr. Smith?
I'll say about 2-3 months.
2 or 3 months?
Yes.
All right, here's what I'm going to do. Get it paid by September 30th. Okay?
Yes, Your Honor.
All right. Thank you, folks. You
All right,
take
thank
care of
you, Your
yourself,
Honor.
so have a good weekend.
You too. Happy Father's Day.
Thank you, sir.
You're welcome.
Court calls the case, People versus Kevin Stevens.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Stevenson. Mr. Stevenson, please state your name for the record.
That was she didn't know if he was here or not. That was a hopeful. Please state your name.
No, did talk to Mr. Stevenson yesterday. We did.
Did you?
Have a resolution. Yeah, you sound like you didn't believe me.
Whoa. I didn't say I didn't believe you.
Okay.
I just was reiterating what you said. I don't know how you talk to these people like yesterday and then they don't show up. I'm not sure what's going on in that conversation, but go ahead.
Frankly, I don't know either, Judge. I don't know why he's here. I did provide him with Zoom information, and again, we did have. Well, actually, he tried to log on yesterday. He texted me that he was waiting in the Zoom hearing at like
24 hours.
2 p.m. And then I told him it was for 6. So
So you think that saves eventually?
maybe it depends on.
Nope. Go ahead. I understand, but we'll figure out. I don't know where he would be. Bench warrant will issue bond 5,000, 10% privilege. Those warrants will issue immediately to go along with the other ones he had. Court does call the case of the People versus Nicholas Stocker.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Stalker. Mr. Stalker, please state your name for the record.
You have to unmute, sir.
Oh, sorry about that. Nicholas Anthony Stalker.
All right.
So, Your Honor, Mr. Stalker was in bench warrant status for a while. I think because of that, we may have old contact information for you, Mr. Stalker. I attempted to call and email a few numbers, but we obviously did not make contact. So what I ask you to do is call the public defender's office and update your number.
Okay, definitely. I can do that.
All right. I'll adjourn. I'll adjourn this to July 2nd, 2025, 9 a.m. All right. Thank you, sir.
Thank you.
Court does call the case People versus Elizabeth Raggett.
Conrad Siller on behalf of Pittsfield Township.
Is that you? Come on up. It's your case. No. This is an arraignment. All right. Hello.
Hi. Thank you for letting me go to my son's graduation last week. Or you let me. Thank you.
You're welcome. How was it?
It was good.
Uh-oh. You all right?
Thanks. Not ideal.
All right. Say your name again, please.
Elizabeth Raggett.
All right. All right. I have to give you I have to arraign you on these charges. You're before the court on a misdemeanor complaint that alleges that on or about March 27, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you operated a motor vehicle with a high BAC. You understand that charge?
I understand.
All right. That is a misdemeanor. It's punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services.
I
understand all of that?
I understand.
All right. My first question to you is, do you wish to be represented by an attorney?
I do. Yes, please.
All right. This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mrs. Raggett. We waive any further reading, stand mute to the charges, and ask for a new pretrial date, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. or as your invite indicates. Alleged BAC in this matter.
Your Honor, it's a search warrant .191. There was a crash.
Excuse me.
In the vehicle.
Ms. Parody, is there anything you want to say on behalf of your client?
Your Honor, I'd request a personal bond standard conditions and drug and alcohol testing. If I may, Your Honor.
I'm not driving at all. I'm not. That's fine.
Do you have a preference?
To anything that.
No, it's gotta be this one.
You put on your ankle.
No, we'll do
I can blow into something.
So my client did indicate that she's not driving at all at this time. She would prefer a SoberLink device if that's amenable to the court.
All right.
But then I could still, like, if I wanted to swim or something. Okay, sorry.
I'd set the defendant's bond at a $20,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possessions of any weapons or anything fashioned to be a weapon. You understand that?
I understand.
I'm also going to order that there should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. I will order that you report over to Community Corrections for placement on a SoberLink testing device. All right. And I've signed that order. All right.
Thank you.
Thank you.
Thank you.
Take care.
Okay, I'm gonna ask you for your phone number.
Okay.
Court does call the case People versus Xavier Ruffin.
Conrad Soler on behalf of Pittsfield Township.
Which one's?
They're both on. Sorry.
Well, I have 4 when you say.
Oh, so sorry.
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 When should I vote?
Xavier Ruffin, no response. Bench warrants will issue for defendant's failure to appear. Bond will be $5,000, 10% in each of these cases. Those warrants will issue immediately. Court does call the case of People versus Sidney Wack.
Conrad Soler on behalf of Pittsfield Township.
This is an arraignment.
Sidney Wack, no response. I'll issue an order to show cause. The court calls the case of the People versus Brandon Wingate.
Conrad Soler on behalf of Pittsfield Township.
This is also an arraignment.
I'll issue an order to show cause for defendant's failure to appear. Is that all we have? Motor vehicle without security.
Yes, sir.
You understand that charge?
Yes, sir.
That's a misdemeanor punishable by up to 90 days in jail, a fine between $200 to $500. You understand that?
Yes, sir.
Okay, my first question for you is, do you want to be represented by an attorney?
No, sir.
Okay, so what are you going to do on this case?
I would like to pay the fine if I could.
Okay, you understand that this is a misdemeanor charge?
Yes, sir.
It carries potential jail time. It's unlikely, but it carries potential jail time.
Yes, sir, I understand. I generally don't ever do that.
Okay,
I've
well,
had the same insurance company.
I don't want you to say anything that admits to anything.
Okay.
Okay?
Yes, sir.
So, do you want to be represented by an attorney?
No, sir, I just.
Okay,
No,
so
sir,
what do you want me to do, ma'am? What are you going to do on this case?
Could I please pay a fine and not go to jail?
Okay, look. You would have to plead guilty to this charge. Do you really want to do that right now?
Yes, sir. Yes, sir.
Okay, let me ask you this. Let's say there might be the possibility that if you have insurance, everything can work out and it can be beneficial. You may or may not owe anything.
Yes, sir.
So would you want an attorney to help you through that?
Yes, sir, if I can get it over
great.
with.
This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Stewart, we would waive any formal reading, stand mute, ask for a TR bond as well as an adjourned pretrial date, please, Your Honor.
Defendant having wait for a reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to what date? July 2nd. I actually knew that. I thought July 2nd, 2025, 9 a.m. Defendant's bonds $5,000 personal recognizance bond. I'll order standard conditions: no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. Okay, ma'am. So get in contact with your attorney. You have the public defender's office, and they'll see what they can help you work out on this.
Yes, sir.
All right, fantastic.
Thank you, Your Honor. And Ms. Stewart, if you can call the main office for the public defenders and update or give a good phone number for you.
Do you have that number? I'm
Sure
not
do.
sure. I live in Monroe County.
You got something to write with?
Yes, sir.
Okay, it's area code 734
734
222
222
6970.
6970, and should I wait until tomorrow to call there?
No, call them today. Give them your name,
Okay.
give a good email and a good phone number.
Okay, thank you, sir.
Thank you. Have a great week. Well, not weekend. I guess it's on.
Thank you.
Like that day. Thank you. Court calls the case, People versus Nicholas Stemmel.
Ashley Lonnie for the people.
Arraignment. Okay. Easier. What's your name, sir?
Nicholas Stimmel.
All right. Sir, you are before the court on a misdemeanor complaint that alleges that on or about September 25th, 2024, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit an assault and or assault and battery against a Reggie Harrell. Do you understand what you're charged with?
Yes, Your Honor.
All right. That is a misdemeanor, punishable by up to 93 days jail, $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
All right. First question I have for you, do you want to be represented by an attorney?
Yes, Your Honor.
Yeah, okay, fantastic. He was listening. This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stimmel, who stands to my right, we would waive any further readings, stand mute, ask for an adjourned pretrial date, as well as a PR bond, please, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. or as your invite indicates. Defendant's bond will be set in the amount of $5,000 personal recognizance bond, including no assaulted behavior or possession of any weapons or anything fashioned to be a weapon. You understand that, sir?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, Your Honor.
I'm also going to indicate you're not to have any contact with Reggie Harrell. You understand that?
Yes, Your Honor.
All right. Thank you. Court calls case, People versus Jim Valensky.
Ashley Lonnie for the people. That's fine.
Yes.
Perfect. Thank you.
And
Oh, it's you, sir?
Yes.
Come on up. Your name?
Jim Valensky.
All right. Sir, you are before the court on a misdemeanor citation that alleges that on or about May 10, 2025, at the location of East Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, that you operated a motor vehicle without proper security and or insurance. You understand that, sir?
Yes, I do, Your Honor.
It's a misdemeanor, punishable by up to 90 days in jail, a fine between $200 to $500. You understand that, sir?
Yes, sir.
All right. My first question for you, sir. Do you wish to be represented by an attorney?
No, sir.
Okay, what do you want to do on this?
I want to plead guilty and pay the fines, whatever is involved.
Is that really what you want to do?
Yes, sir.
Let me just say this. What if there were an opportunity that if you were to present certain documentation regarding now having insurance, this could all work out in a very different way where you might not have to pay a fine?
Well, I already have that information available.
Okay, so somebody has to help you through that process to be able to get that and to try to maybe work that out, right?
Correct.
So then I would ask you once again, do you wish to be represented by an attorney?
Yes, sir.
Thank you. This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Valensky, we waive further readings, stand mute, ask for an adjourned pretrial date, as well as a PR bond, please.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned July 2nd, 2025, 9 a.m. Bond is set in the amount of $5,000 personal recognizance bond on order standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. All right, thank you.
Thank you.
Thank you, Your Honor.
734-213-2064.
207-213.
Yes.
I don't understand. I think I'm
Have comment.
speaking
Thank you.
French. Don't understand. Let's try this. Court does call the case People versus, is it Bonai Williams?
Echelon, people. This is a show cause.
Bonai Williams? No response. Bench warrant will issue for defendant's failure to appear at the show cause. Bond is set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue. Court calls case People versus Tony Williams. Tony Williams, no response. I'll issue an order to show cause. Court calls case People versus Christopher Akron.
Conrad Silver on behalf of Pittsfield Township.
This is a public.
Oh, what is that? Nothing.
Sorry, I think I might have missed something. But I
You
do
did.
have- or I guess I should say my name. Assistant Public Defender Natalie Pavlich on behalf of the client, Mr. Chris Akron, who is present via Zoom. Sir, can you please state your name to the court?
Chris Akron.
Thank you, Your Honor. So Mr. Akron has been diligently working to try to get proof and documentation that his vehicle